Um, I would like to begin by reading out a statement, which in return I would ask Justice Sir Cooke and the Council to confirm is correct. I hope that is okay. This application hearing is in the matter of case number CFI 087-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke. The judge hearing this application is appearing from London. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed.
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 Thank you.
You.
The claimant is represented by Horizons & Co. Law Firm. Lead counsel is Mr. Stephen Doherty. The defendant is represented by MB Camp LLP. Lead counsel is Mr. Michael Patchett Joyce. Thank you.
That's correct. And could I just add that I'm assisted by Mr. Salamatu?
Yes, I've already spoken to him in your absence.
Thank you, Your Honour. Yes.
Is there a measure of agreement about the order in which we're going to take these applications? I take it the privacy thing ought to come first, and thereafter it's a question of whether there's agreement between you as to what happens next.
We haven't had the opportunity of discussing what happens next, but I did try, as you've seen, to set out a suggested approach, which perhaps will commend itself to my learned friend.
Yes, Your Honour, I'd seen what my learned friend suggests. I think we're both agreed that it's sensible to address privacy first. It seems a more standalone issue. Obviously, to some extent, we're in your hands as to what you think you would be most assisted by. For my part, what I would suggest is that we deal with the claimant's applications first, followed by the defendant's applications, and that there are a number of reasons for that. First being that the claimant's applications involve what in my submission are much more confined issues, what you might consider more traditionally fertile ground for summary disposal. So they're narrow points of law. The second is the fact that we're looking at part of the defendant's case, which we say not only does the claimant have real prospects of success, but it's one where the defendant, in fact, has no prospects of succeeding. Somewhat cuts against what is going to be the broader application made by the defendant, which is that you can enter a summary judgment, immediate judgment over the whole thing. The third point is that if we hear the defendant's application first, it's not going to be dispositive of
Sorry, Stephen, you're on mute.
Apologies, have I been on mute the whole time?
No, you just clicked it accidentally.
Oh, right. Where was I up to? I think I was saying that the defendant's application wasn't going to be
dispositive, I think, yes.
Because we're going to have to grapple with the discrete legal issues raised on the claimant's applications anyway. And ultimately, I think it comes down to a question of structure. We say that the defendant's application is inherently, for want of a better word, messy. It involves lots of complex fact patterns. It involves consideration of each and every head of claim, and there's, to that extent, a bit of a timing issue. One could take the view that it's best to deal with the discrete legal issues up front so that those are dealt with, and as one goes through the submissions made by the defendant on its application, one of the possible outcomes, Your Honour, is that you take a view that looking at it, stepping back on a broad brush view, this isn't a matter for summary determination at all, it's a matter for trial, in which case there's a good timing issue for dealing with the discrete points first so that you understand them before coming on to the much broader application after that.
Well,
sorry, Your Honour, you're on mute.
Your Honour, just by way of brief response to my learned friend, we don't want to spend a lot of time engaging on the forensic minutiae of this. Whatever is convenient to the court will, I'm sure, be convenient to us. And at the end of the day, the court can sit back and review all of the submissions, which will, I anticipate, follow our respective skeleton arguments fairly closely, and take a view in the light of all of the submissions, however convenient it is for those to be presented, Your Honour.
Yes. Well, it's inevitable that having read the papers, that some detail, including 30-page letters from Mr. Matu, about which I say nothing for the moment. I have some preliminary views, and I think it might be sensible for me to outline those, at least so that you know what is best for you to address. The first is simply on the privacy thing, where I'm prepared to listen to anything anybody wants to say, but at present I find it quite hard to see there's anything very special about this case. If there are particular trade secrets and so on, then there may be room for a confidentiality ring of some kind. But beyond that, for the moment, I can't see that there is any particular element of confidentiality or sensitivity that would require the court to hear matters in camera. So that's the first point. But Mr. Doherty, I'm very open to listen to what you may have to say about that. The second point is this, that at the end of the day, there are plainly issues of fact here, which I think are going to make it difficult for me to decide summary disposal, certainly on what Mr. Patrick Joyce wants to put forward. He has, it seems to me, clearly some points to make with force in relation to the manner in which the case is pleaded. But the real case, as I see it, that the claimant is putting forward has to be taken from Mr. Tim's first witness statement. And one can take pleading points at the end of the day, but this court is ultimately going to be concerned with doing justice in relation to whether or not there was a justified termination of employment with cause or not, and what then flows with that. Mr. Patrick Joyce is obviously right that if there was, if there's no claim that the claimants can properly make, then there's no basis for set-off in relation to whatever sums may be owing in respect of wages and commission and expenses. What I would like to try and do to get this case on the right footing is to move towards identifying the real issues and getting them properly pleaded and dealt with. I think that's probably all I need to say for the moment. Whether Mr. Doherty's discrete points are capable of being dealt with in the way that he wishes is, I think, a matter for argument. I hope that's helpful. I don't have concluded views, but I do have a general sense, having read the papers in some detail, that there's a need to be much more defined in terms of the issues and get those dealt with. However you look at it, Mr. Patrick Joyce, it seems to me there are real fact issues here. However inadequately the matter has been pleaded thus far.
Your Honour, obviously, I hear for present purposes what Your Honour says, but in terms of proper sequencing, one needs to have the case properly pleaded in order to know the case that one is responding to.
I entirely understand that, Mr. Patrick Joyce.
So I hope Your Honour doesn't feel it discourteous if I rather park the second element until the first element is resolved.
Yes, well, I don't expect you to simply take it on the chin, Mr. Patrick Joyce, but I just thought it'd be helpful to indicate the way I'm thinking so that you know the areas that you need to address.
Yes, that's very helpful, Your Honour.
And before we go to the privacy point, Mr. Doherty, the way the claim is put does seem to me to be different in the statement of claim from the way in which Mr. Pin puts it. And conflict of interest isn't quite the right issue, is it? I mean, there may be a conflict of interest between the senior employee of the Bank of Singapore and the bank, which is detrimental so far as the claimant's business is concerned. But the way Mr. Chin puts it in terms of diversion of business from the Bank of Singapore to King's Barn Consultants and the interrelationship of the husband and wife in that context, that doesn't seem to me to be quite as the matter is put in the pleadings.
Indeed, I take your point, Your Honour. I think fundamentally what the point is, or what I suppose the crux point of the case, the circumstances surrounding the dismissal and so on, is ultimately that a set of scenarios were created which led to the withdrawal of business from the company. And that leads to a whole host of claims under contract, arising under statute, and so on. So the existence of that conflict of interest from the managing director of Bank of Singapore's perspective is what we might call the conflict of interest. The actual problem from an employment perspective, and what gives rise to the claim, is that the employee is putting the company in a position where he is acting dishonestly, and it's leading to its clients and its referral sources withdrawing their business. Really, that's the crux of the issue. So I well take your point that one can get lost or overly focused on the idea of this being a conflict of interest. That's the factual background to the claims being made.
But it's a conflict of interest that exists between the employee and the bank, isn't it?
Sorry, when you say the employee, you're referring to the defendant, or you're referring to the employee of the bank?
The bank's managing director, or whatever it was. I lost track of what his position was, but the senior employee of the bank, who's instead of using them as so they get the referral commission, he uses his wife's company, and then the wife's company is used for a number of other things as well, which they now say they weren't used for. But
yes, quite right. And it's that conflict of interest which we say was concealed and ought to have been identified, and that's what ultimately leads to what are the breaches in this case. So the breaches in this case are the employee, the defendant's dishonesty in permitting that state of affairs, in allowing that diversion of resources, and ultimately leading to the withdrawal. Really, that's the point. Yes. So yes, we accept that the conflict of interest ought to have been identified as with the bank, but that's not what we're saying the breach is.
No, well, let's look at the pleadings in due course. Let's first deal with privacy before we do anything else. Otherwise, discussion is inhibited.
Yes,
Mr. Doherty, you better address me on why you say that this is a particular case that requires one to act contrary to the general principle in Scotland, and so on and so forth.
Yes, well, Your Honour, can I just start by saying I don't think really there's a fundamental disagreement between us on the law. It's a matter for judicial discretion. I don't propose to go into it in any detail, but what I will ask Your Honour to look at very briefly is the Arkham decision. And can I just ask Your Honour what way you're looking at the bundle? Have you downloaded a PDF where you've got sort of page references running to the thousands, or are you using the platform, just so I know what type of reference to give you?
Well, I've done both, but I had real difficulty in identifying the numbers from both of your skeletons in either case.
I suspect it may well be teething problems from adjusting to the new system and what's easiest. Well, if it helps,
what I've got in front of me is the case lines, or whatever it's now called, the system that the court uses. So I've got it online, not downloaded. It's just the way it appears, which I haven't quite got used to navigating my way around. It's a little different from the previous one.
Yes, well, I'm happy to navigate you through whichever is easiest. So the Arkham decision is at section G, tab 2.
Okay.
And the page number is 1603.
Now, is there an easy way of getting? All right, let's try that.
Yes,
one
so
page.
there's a search function right at the top where you can just type in the page number, and I suspect that that's probably going to be the easiest way.
So I've got to paragraph 19.
Yes, correct, which is what I'm looking at. Now, Your Honour will appreciate this is in the context of proceedings before the Financial Markets Tribunal, but we say the statement of principle broadly holds for proceedings before the court. So this is on appeal to the Court of First Instance. So paragraph 19 begins by referring to grounds on which the matter was appealed to the CFI. The point of principle starts halfway. It's 1, 2, 3, 4 lines down, beginning in my view.
Yeah.
So in my view, there's no substance to that criticism. The hearing panel was plainly correct in its view that it required some good reason to depart from the principle, i.e. the default principle of open justice, that hearings should be in public. It was plainly correct also to recognise, subject to the advisor in the second sentence of Rule 15, no hearing shall be in public, where all parties request the hearing be made in public, and then it says that the court has a discretionary power to order that all of the part of the hearing are in public. So just a couple of points. Of course, starting point is that it's in public. What's required to depart from that principle is a good reason, and it's a matter for the court's discretion. And if we go then to the bottom of that page, paragraph 22, and this is
forgive me, I can't even highlight a passage in this. Mark an area doesn't seem to do anything.
Oh yes, I can see that as well.
Does anybody know how that works? How do I highlight a passage I want to I've just gone to mark an area and then tried to highlight something, but it doesn't.
I'm afraid I don't. I have a notification that at the top of my system that says that guest users may not have the option to make notes and comments, and I don't know if you have that as well. Although
No,
I'd be surprised if you were a guest.
In case you've made notes or comments, please save them before proceeding to the next one. Oh, well, perhaps let's try marking it and then saving it. Maybe that does it. Forgive my stupidity. The DIFC did offer a course to help one understand this, which I couldn't then make. Let's try that. No, that doesn't do anything.
I have to say, when I tried, it just highlights the entire page and nothing really happens.
I share the concerns about the user friendliness. I'm sure we'll all get used to it, but it is rather difficult.
But have you worked out how to do it, Mr. Patrick Joyce?
No, I've printed off in hard copy. I've gone back to old-fashioned techniques of printing off those passages that I think are necessary.
Yeah, hold on. Let me just try something else. Add a comment. No, it won't let me add a comment either. All right. Well, never mind. We're going on. Sorry, to paragraph 20.
Paragraph 22.
Yes.
About halfway through, five lines up from the bottom, beginning but.
Yeah.
It says, but in reaching its conclusion to refuse an order for non-public hearings, the hearing panel did ask itself whether the hearings in public would give rise to significant or disproportionate harm to Arcam's legitimate business interests. In paragraph 63 of its decision, it concluded they would not have that effect. And then it goes on to its factual finding there. But the relevant consideration really is that the fact that proceedings taking place in public might cause harm to legitimate business interests can be a reason for the court exercising, or in this case, the tribunal exercising its discretion. So in effect, if the disproportionate harm that might be suffered outweighs the public interest in hearings proceeding in the open, an order can be justified. In effect, it's a balancing exercise where you have the starting point that hearings take place in public. Pausing there, one point that may be a point of difference worth highlighting is that Arcam, as I say, is a set of proceedings before the Financial Markets Tribunal. And whilst one can plainly see the public interest there may be in disciplinary action being taken by a regulator against an authorised firm, in particular, because of course there will be some element of that which is about protecting the public who might be involved with that particular financial services provider. One could at least see the argument that there is less public interest when we have a commercial, and in particular in this case, an employment dispute. And indeed, we say that's something which is impliedly recognised by the DIFC court, which routinely hears employment disputes in private. And on that point, I'd refer Your Honour to RDC 53.52 concerning employment claims in the Small Claims Tribunal.
Reference again?
Part 53.
Yeah.
0.52. Oh, I closed my tab that had my rules on it. Let me just pull that up as well.
Well, I'm looking in hard copy, so
So as I'm sure Your Honour may be aware, the default in employment disputes, particularly where they're under 500,000 dirham, is that those disputes will be heard in the SCT. And what 53.52 provides is that the general rule is that a small claim hearing will be in private unless the parties agree or the SCT judge orders otherwise. Now, of course,
I'm having a problem identifying 53.52.
It's in the section dealing with conduct of the hearing, which I'm looking at the rules that are currently online in the DIFC's website.
Yeah, if Your Honour has those online, it's page 603 of 695.
Is it in the bundle?
No, it's not in the bundle. It's not directly. It's not a rule which directly applies.
I'm looking at that.
We may have to have a word with Mr. Reid and Mr. Montague Smith.
It doesn't seem to be in there. When you say 53.52,
yes,
is about representation at the Small Claims Tribunal hearings. In this, what date is this?
Yes, in the current iteration of the rules that's online, party representations dealt with at 53.55.
Okay.
I do have a copy of DIFC court practice, so if you give me a moment, I can probably pull that up to see.
Conduct of the hearing, here we are. Yes, I've got it. It's 53.47 under the old rule.
Okay, right.
Yeah, okay, yeah.
And so it's simply an update.
Yeah.
So the point there really is that the DIFC court's rules already accept that it's appropriate, at least in what would be the majority of employment cases, i.e. those going before the SCT, that those take place in private. Now, this is, of course, a case which falls outside that jurisdiction because the quantum exceeds the Small Claims Tribunal thresholds.
By a distance.
By a distance, and we quite accept that. But Your Honour will no doubt also observe that there are a multitude of employment judgments out there which have been, first of all, cases conducted in private, but ultimately the judgments then anonymised in accordance with Practice Direction 3 of 2016. So the first point really is that it's not at all uncommon for disputes like this to be conducted in private. In fact, disputes involving these fact patterns quite often are subject to a default provision that they do take place in private, with the major distinction here really being one of quantum rather than one of public interest in that sense. And the second point relates to Arkham and the harm which we say publicity is likely to cause to the claimant's legitimate business interests. And in fact, what we say is that the defendant appears to be very aware of that, and indeed that is the driving force behind what we say are some of the extraordinary allegations that he sought to put before the court in these proceedings and sought to rely on as evidence. And I don't wish to dwell extensively on what those allegations are, in part because giving them any more ventilation in a public forum somewhat defeats the purpose of this application. But I'm happy to run you through a few examples of what we're talking about. First of all, by reference to the defendant's legal representative letter sent at the beginning of this year. And secondly, to show you how that tracks across with what he's put in his witness evidence. But if you want to look at that, it's at page 229, which I think if you put it into the search field at the top of your electronic bundle should come up. That seems to be the easiest way to navigate.
Yes.
So this is the letter sent on the 19th of January 2023, put into evidence in these proceedings in a number of exhibits. But just to take you through a couple of examples. First of all, if you go to page 230, the very next page, we can see, first of all, at paragraph 4, this is where we have set out one iteration of what we say are entirely baseless allegations regarding the claimant's authorizations and the manner in which it conducts business, and the allegations that it's conducting business illegally in the DIFC. It refers to your client putting together a scheme to launder application deal documents. So we're talking about extremely serious allegations which would be extremely harmful to the claimant's business on the basis of no evidence whatsoever. And in paragraph 6, we have threats, amongst other things, to refer these issues to Dubai police, the public prosecution authorities, to the US Department of Justice, the Serious Fraud Office, the SEC, and so on. And it continues beyond those sorts of allegations about business into other areas as well. So jumping forward, if one goes to page 236 of this same letter, and at the bottom of this page, together with the top of page 237, and again, what I hope are for obvious reasons, I don't propose to read that into the record. I'd leave your honour to look at what's said there.
Yes. Well,
in effect, a series of deeply personal attacks on Mr. Calvin Lowe, a number of salacious allegations regarding, amongst other things, his education, his family life, his extracurricular activities. Again, all of which are completely baseless, completely unevidenced, completely irrelevant to the issues in these proceedings. And it's not just Mr. Calvin Lowe. If we go to page 239 at the bottom of the page, you can read it's paragraphs A and B. But again, what we find there is, again, a number of unfound, untrue, extraordinary allegations about the personal conduct or misconduct of employees of the claimant, which again has nothing to do with these proceedings. At page 244 of the same letter, it's allegations of criminal activity, and we have, in effect, 30 pages of this. And what's clear, we say, is that those allegations have leaked into and been presented as evidence in these proceedings. So if one goes to page 122, Here we have a signed witness statement. This is the defendant's first signed statement.
Yeah. Well, the great chunks simply repeat what's in the letter.
Yes, quite. So what we say is it's introducing into the record, introducing as evidence in these proceedings, is information which touches on the claimant's business, which is clearly intended to be damaging to the claimant's business. They are very, very serious allegations. There are also very, very serious allegations made about a number of individuals. So, for example, in paragraph 6 of this page, we can see the beginning of personal attacks against employees continuing. So there's the references to Mr. Parker. And again, certain extracurricular activities, those are continued at page 133 and 136 of the witness statement, which recites some of the more salacious allegations that were already set out in the letter. And again, I don't propose to take you to it all. It continues in the second statement as well. Yeah. Page 155 to 156, we see the same allegations about Mr. Lowe's professional life, his ownership of a Formula One team, his education, and again, his family life. And we say it's quite alarming enough that the defendant saw fit to have his lawyers put that down in a number of 30-plus page letters, but it's quite something else to find that information, which is completely irrelevant, provided in a signed witness statement. And what we say about that is that the defendant's strategy, misguided as it may be, appears to be taking concerted steps to cause maximum embarrassment to the claimant, in turn, to hurt its reputation in the market. And that's clear, we say, from the allegations that both it and its business partners have been apparently conducting business in the DIFC and elsewhere illegally. And that in turn is intended to and is likely to affect the claimant's business interests in the region, which has a direct effect on its bottom line. Indeed, the claimant's claim in this case already concerns the extent to which the defendant's conduct caused particular reputational issues, which resulted in material financial losses. And the defendant's conduct of these proceedings, we say, demonstrates his intention to continue causing that kind of collateral damage. And we say that, first of all, in this case, the public interest is outweighed by the material risks to the claimant's legitimate business interests. Secondly, we say that there's it's in accordance with the overriding objective to make this order, because clearly there is some concerted attempt to put all of this into the public domain, because it's seen as I say, it's misguided, but it's seen as being some kind of leverage point that the defendant has. And one can take a view that the court ought to discourage that kind of behaviour, which is precisely what an order for privacy would do. And the third point is that making that sort of order in reality would not be particularly inconsistent with DIFC court practice, in that the majority of employment cases are dealt with by the SCT in private, where the only real distinction in this case is one of quantum, rather than there being any particularly special public interest in this case.
What's the position on appeal from SCT decisions, where privacy has been privacy in the SCT?
I can try and find that out for you. From practice, my understanding is that the judgments made by the CFI in relation to appeals from the SCT still contain the same anonymization that appears in the arising from practice section 3 of 2016. So the anonymization, as far as I'm aware, carries across in appeal judgments, and so that would imply that privacy remains
Yeah, there's a sort of note that half deals with it in the Montague Smith Reed court practice, doesn't seem definitive. And my experience is actually to the contrary of what you've said, but the point has never been argued. So I don't know. Perhaps we could look at that.
Yes, I'll see if I can find that.
Is there anything else? Is there anything else you want to say about privacy, really?
No, really, that's the crux of it. A lot of the detail, I think.
Yes.
Well, I hope Your Honour understands. I don't want to get into and go through in detail for obvious reasons.
Yes, Mr. Pratchett-Joyce, I'll tell you what I'm inclined to do even before hearing you on the subject. But that is to deal with the matter today in privacy, in camera, in order that the parties are entirely free to say whatever they want. Because at the end of the day, as I've already indicated, I think there's considerable scope for narrowing of issues and exclusion of irrelevant material, which would largely meet the concerns which have been advanced. So I'm inclined today to hear this application in private, and then to decide at the end of it exactly what we do from here on in, depending on the other matters which have to be canvassed. Do you have a difficulty with that?
Well, subject to taking instructions, it seems a relatively, and I put some stress on the word relatively sensible way forward, but it's rather indulgent to my learned friend, because what has happened in the course of his submissions is that he's taken the court rightly to the test in Arkham, which is of significant or disproportionate harm. He's then sought to extrapolate the position which is across the board in the SCT of anonymization. And we're all familiar with the some name beginning with L against some name beginning with L, the next year M against M, etc., etc. So that is standard across the board in the SCT, and in my submission, our submission, the same read across does not apply to the court of first instance. And then my learned friend has really migrated from privacy to consider his application for striking out of certain specific points, notably the letters, and Your Honour has seen the responses that we put into that. I'm happy to address Your Honour in detail on that, but if we're looking at privacy, then in my submission, one does go back to what is set out in our skeleton, page 6, beginning at, it's the first part of the skeleton, begins at paragraph 18, goes through over the page to paragraph 26. And in my submission, when one looks at Rule 35, when one looks at the parallel rule in CPR Part 39.2, and one looks at the evidence that my learned friend's witnesses have advanced in support of the argument for privacy, it really doesn't meet the test. My learned friend, if one looks at what is presently before the court, privacy, those are my submissions. If my learned friend is going to expand it into his strikeout application, then that's another matter. On the point about anonymization carrying over, I would need to do further research as well, but my clear impression is that when it reaches the court of first instance, names are used, but that's subject to further research, Your Honour.
Well, I've no doubt at all that names are used. I was simply on a permission to appeal I was hearing yesterday. The names were used. but nobody had argued the point. So whether an educated view had been taken or the court had just done what it normally does, I'm not sure.
Mm.
Anyway, that's very helpful, Mr. Joyce. What I'm going to do is to say, pro tem, I'm going to hear this in camera. And when we get to the end of it, I shall make a decision as to whether the whole transcript then becomes open or not. But it will enable people to make their submissions fully and freely in relation to striking out summary judgment or whatever else, without any concern that they're doing their clients any damage in the circumstances. So this is simply a temporary order on the basis that this significant and disproportionate harm may be caused if the matter is heard in open court. And it's impossible for me to form a view about that until I've dealt with the other matters that have to be determined in this application. Mr. Patchy-Joyce, when you're not talking and you're writing, your camera is bouncing you up and down.
Oh, my apologies. Would you like, is that distracting?
Well, it is.
Right.
You could either turn your camera off if there's no way of stopping your movement, so to speak. I think it's probably when you're writing that it,
yes, it will be.
Has the effect of disturbing wherever your camera is placed.
Yes, I've got, I wonder if, let me revert to the laptop camera, which will be of inferior quality, but it may stop the shaking.
Have you got a webcam or something? Yes,
and I've now taken that off, and you now have.
Yeah. Well, that's you.
Let's see if that works. And I mean, I'm not writing at the moment, so I don't know whether it's still having the same effect.
Try writing something and see if it has any impact. Oh no, that's all good. Oh well, okay. No, it still does a bit, but never mind.
But less.
All right. So there we are. That's the privacy thing for the moment. Tell you what I think I'd like you to do, Mr. Patchy-Joyce, and that's to address me as to why there aren't questions of fact which arise on your applications, allowing for the inadequacy in pleading as you say that it is.
Your Honour, yes. Let me try, therefore, to cut to the chase in answering the question. We say that the claim is inadequately formulated and should be struck out. And that's the first stepping stone in relation to our broader application for immediate judgment. We also, as Your Honour will have seen, rely clearly on Order 24, Rule 14, which is the order and the rule which allows the taking of an account. We've set that out for the court's convenience at paragraph 60 of our skeleton. If a remedy sought by a claimant in his claim form includes or necessarily involves taking an account or making an inquiry, an application can be made under Part 24 by any party to the proceedings for an order directing any necessary accounts or inquiries to be taken or made. Now, we fully accept that there would need to be a taking of an account, probably consequent on the making of an inquiry in relation to quantum. Yeah. But what we do say is that in relation to liability, it is very clear that we are entitled to a very substantial amount of money simply because Mr. Khan was extremely good at his job and he earned high rates of commission. Your Honour, if one looks at the relevant contract of employment. And in this regard, I need to take, Your Honour, to, let me see, it's best seen at tab D15.
Yeah.
And D15, again, I'm afraid I have it in hard copy, but it starts with the engagement letter and then goes on to the contract of employment. And I'm just getting that up in front of me as we speak. So I can give Your Honour the page number. If one goes on to the contract of employment begins at page 13 of 32 in bundle D15. And then if one goes on to page 15 of the same bundle, we have the heading remuneration. And then going on to page 16, 5.8, when commissions are earned, a commission shall be deemed earned for purposes of this agreement upon completion of all of the following events, 1, 2, 3, 4. And then it's quite clearly and categorically stated, upon the termination of your employment, for any reason or no reason or cause, you will be entitled only to commissions earned pursuant to the preceding sentence, up to and including the date of termination. So we are entitled to commission for whatever reason that the employment has been terminated.
I'm terribly sorry, I'm just not with you at all. I'm struggling because I printed off some hard copies too.
I think it may be page 1295.
Right, okay, thank you.
1245.
1245, thank you. Let's try that.
My apologies, Your Honour.
I mean, it sounded from what you were reading as though it was what I'd read elsewhere, but
yes,
5.8, yeah.
It's 5.8, yes, in whatever convenient form the court has 5.8 in front of it.
Yes.
And it's really, I read the whole lot, but I'll just recap the final sentence, if I may. Upon the termination of your employment for any reason or no reason or cause, you will be entitled only to commission earned pursuant to the preceding sentence up to and including the date of termination. So you've seen...
When would it be payable? Is it payable at the end of the calendar year, in fact? I mean, the calendar year is past, so it probably doesn't matter for current purposes, but I wondered about that.
That is an interesting question, Your Honour. In our submission, it's payable within 14 days of termination.
By reason of the statute.
By reason of the statute. Now, I can see that the termination was in the middle of September last year. If it works on a calendar year basis, Your Honour, then there are two positions which can be taken. Obviously, steps 1 to 4 will have been taken in relation to the vast majority of the transactions on which commission is to be calculated as of that date. And therefore it is, and indeed all of those steps have to be taken. So as all of those steps will be taken, it's within the knowledge of the claimant to know exactly what the commission is. We've adduced evidence as of the 5th of September that my client had done business, transacted insurance to the value of about 13.6, 13.7 million US dollars. The precise knowledge, precise quantification, is within the knowledge of the claimant. And the claimant will know and could have calculated as of the 14th of September exactly what the commission was due and owing up to the date of termination, because they know all of the 4 requirements and they know all of that information. So we say, yes, it should be 14 days. There's no reason why it shouldn't be.
Well, let me just raise a hypothetical, which may not be entirely hypothetical, in fact, depending on how the facts pan out. Suppose, for example, on the as at the 14th of September, policy premium has been paid, policy has been delivered, delivery requirements have been satisfied, and I'm not quite sure I know what that means, and commission has been received. And then thereafter, within the cooling off period, the policy is cancelled. Is that a possibility or not? Or is it, are those other conditions not met within the cooling off period?
On that, I would need to take instructions on the detail.
Well, so, I'm just wondering how easy it is, therefore, to work everything out exactly as at the 14th of September. But none of, and the point, there's no evidence about that. It's plain that they must be conscious, certainly, that some of the business is entirely complete. Though I think in relation to the particular policy in question, it wasn't in the end taken up because it was cancelled during the cooling off period, I think. Is that right?
Let's certainly one policy was there is evidence that one policy was cancelled. It will need to be investigated. But let's take Your Honour's hypothetical position. If the full commission is calculated and paid, then that satisfies the mandatory requirements of the employment law. If there is overpayment because of an ex post facto withdrawal of the arrangements during the cooling off period, then there would be a claim back by the claimant against the defendant for the commission, depending on the circumstances. One would need to look at it. But that doesn't affect the primary obligation of the claimant as employer under the employment law, because the claimant can satisfy those obligations by paying the full amount. And if, and it's going to be an unusual circumstance, but if there is any withdrawal during a cooling off period, then it's the basis of a claim on that basis, but it's a claim for an overpayment. So that really it doesn't, in our submission, help the claimant to explore these hypotheticals. The claimant has all of the information within its power to satisfy Article 19. Now, let me just amplify that, because, of course, the cooling off period, there would be at least 8.5 months. If the cooling off period is a month, and again, I'd need to look at the details, but let's, again, for hypothetical purposes, take a cooling off period of a month. That means that all of the business done between January and mid-August is known and quantifiable. And that is essentially the first step in the way we put our case. Or at least it's the second step. We say there's clearly liability because there is a liability to pay commission come what may, whether it was termination for cause or for no cause. So liability is established, and quantum, we say, is quantifiable in a very substantial sum once we have got the relevant material from the claimant. So we say we should have immediate judgment on liability. there should then be the taking of the making of necessary inquiries and the taking of an account. We would also say that there should be an immediate partial payment of that which is on any view clearly due and owing, which is what my client earned by way of commission for 8.5 months on the hypothesis we're working on. And then we can argue over the residual insofar as there is anything to be taken account of along the lines of the hypothetical that you've put. That, in our submission, is the right way of approaching this. What is completely wrong is for the claimant to keep my client out of very substantial sums of money. And, Your Honour, it will not be lost on Your Honour that immediately after the termination of my client's employment, the claimant saw fit to write what in our submission is a plainly defamatory letter, which plainly attacks my client's reputation, and circulated that letter to business partners. So they have aggravated the situation very considerably from day one. And that has had the practical effect of making my client unemployable. And it is quite wrong for a combination of a defamatory letter and dilatoriness in paying monies plainly due that they should put my client in the position in which he now finds himself.
Well, that's I think all of that is fine as far as it goes, if there's no set off of a claim.
Well, yes, but
I mean, I understand why you say that's the starting point, and I can see why you say that. But if there is a valid claim to be made on the basis of Mr. Chin's affidavit, witness statement, what do you say then?
Well, we would like to see the basis on which the claimant puts their case, because I was asked to respond to the question that John put to me, allowing for the inadequacy of the pleading. I think perhaps we should just remind ourselves of what the inadequacy of that pleading is. And I'm happy to take Your Honour to the claim form. The claim form is at A1.
Yeah.
Sorry, it's in a different file. Yes, so if one looks at the brief details of the claim, which is set out on the second page of A1, and again, I'm afraid I have it in hard copy.
Yeah, bear with me a moment. Yeah.
If one looks at the second page of A1, essentially the brief details of the claim read that the defendant, then one can jump to the sixth line, the defendant caused the claimant to enter into a referral agreement with KBC. Then there's the point about the conflict of interest, which has already been explored, and with which respectfully I agree with the question mark raised by the court. They say on the basis of that, that justifies the termination for cause, and then the brief details go on to the data breach, which again I deal with separately, and loss flowing from the way in which the claim is put. So if one goes to our skeleton at page 2, foot of page 2, we've sought to distill the elements of the claimant's claim. Defendant was employed by the claimant. Defendant caused claimant to enter into a referral agreement with KBC. There was, quote, an obvious conflict between the beneficial owner of KBC and her husband, but we failed to see that conflict. D, then going over the page, D caused C to incur a data breach. C suffered loss and damage. And on analysis, Your Honour, only the first element, namely that the defendant was employed by the claimant, is actually correct. Because when one looks at what Mr. Chin says in his first witness statement at paragraph 35, reference given, repeated in his second witness statement at paragraph 7, reference given, it's absolutely clear, and it's put beyond doubt because the referral agreement itself is exhibited now by the defendant in the exhibits to Mr. Chin's second witness statement at pages 55 to 60. Again, the reference is given in the skeleton argument. The referral agreement wasn't entered into by the claimant at all. It was entered into by a completely separate corporate entity, R.E. Lee International Cayman Limited.
Well, I understand that, Mr. Patrick Joyce, but there can't be any doubt that the reason for entering into that referral agreement was the business that was being put forward. So, of course, it's wrong to talk about causing the claimant to enter into a referral agreement, but it causes the claimant to procure that the Cayman Islands company enters into it through Hong Kong and Mrs. Tuti, or whatever her name is. Well, I mean, you're absolutely right. I think it's unarguable that as it's put there, it's not correctly put.
No.
But the idea I'm going to strike it out when in reality it's plain from Mr. Chin's evidence that there is it could be properly expressed as procured the Cayman Island to enter into it. One's got to try and grapple with the reality of it all and try and get the case on the right footing to deal with the points that really matter.
Absolutely, Your Honour. I agree with the final point. And if I may say so, it is encouraging to hear Your Honour express the view that as it's presently put, it's unarguable, because that is indeed the submission that we make in this regard. But in order to address whatever might be arguable, we need to see how it is put, because without going into detail for present purposes, because it's essentially looking at something which will be further down the line, we would very much like to see how this claim is revised and amended, because we think there are answers to revisions and amendments. And until we see how the claimant amends their claim form, amends their particulars of claim, we don't know what we are answering, and therefore we don't know which way to jump.
Well, you know what Mr. Chin says.
I know what Mr. Chin says, but if one looks, and we can look at this in detail if Your Honour wishes, but Your Honour will recall from the particulars of claim that the claimant is identified in paragraph 2 of the particulars of claim. This is A3, page 1.
Yeah, I printed this off. So
yeah. Yes, I have it in hard copy as well.
Yeah.
So paragraph 2, they identify the claimant rightly as Middle East Limited. But then they also identify a different entity, namely a group of companies headquartered in Hong Kong, as RELI, R-E-L-I.
Yeah.
Now, the remainder of the particulars of claim uses at certain instances, refers at certain instances to claimant, and refers at certain instances to RELI. And that, insofar as the claimant seeks to spell out causes of action or a pleading on the basis of RELI and not its own rights and obligations, is again, in our submission, totally confusing. And what we want to know is how the claim is put against us properly. It's not put against us properly in the claim form. The claim form is not properly, or the brief details of the claim set out in the claim form are not properly carried over to the particulars of claim as they are presently drafted. And there is wholesale conflation of the claimant on the one hand and RELI on the other in the particulars of claim as they are drafted. So for all those reasons, we find it not difficult, but impossible to go behind the assumption that your lordship or your honour invited me to make at the outset, namely allowing for the inadequacy of the pleadings. We say the pleadings are so riven with inadequacy that all we can do is assume that the claim form should be struck out, assume that the particulars of claim should be struck out, as we have done in our skeleton argument, and on the basis of those assumptions, which have in our submission to be made on the state of the pleadings as they presently stand, we then look at our counterclaim, and that comes back to the Rule 2414 point that liability really can't, in our submission, be an issue on, for example, commission. And we can go through the rest of the skeleton if your honour would wish it, but let's just take commission by way of example now. There really can't be any issue about liability on commission, and 2414 then enables the court to progress speedily, efficiently, efficaciously to what is really at the heart of this, which is the quantification of the very substantial commission payments, by way of example, owed to my client. That's how we put it.
Yeah, what I'd like you to show me, Mr. Patrick Choice, is where in the particulars of claim the wrongdoing, excuse me, the wrongdoing is alleged against Mr. Khan in the particulars of claim as opposed to the claim form.
Where the wrongdoing is alleged against Mr. Khan.
Yes, that's what I'm keen to grapple with in the context of what's pleaded in the particulars as opposed to what appears then in Chin Witness Statement 1.
Yes, Your Honour. Let me see if we can shed light on that. And what I have in mind is taking the court to paragraphs 30, first of all, paragraphs 33 and 34 of our skeleton.
No. I particularly want you to take me to the actual document, the particulars of claim themselves, in order to identify how the point is put.
Well, I was trying to do that by way of a ready reference, because what we've done is, if Your Honour goes to the foot of page 8, what we've sought to do there is summarise how the substantive case is brought in the claim form. Then if Your Honour goes over to page 9, the substantive case set out in the particulars claim is as follows. And here we've provided what I hope is a guideline by reference to the paragraph numbers in the particulars of claim that Your Honour has in hard copy.
Okay.
So we have the employment, which is paragraph 1, contractual duties, which begin at paragraph 6, then fiduciary duties pleaded 7 and 8, and other duties 9. So we're still in the foothills at the moment. Then it's not terribly clear, but at E and giving the benefit of the doubt to the claimant, we do have the referral agreement, or at least the referral of customers through KBC, and we have the word breach appearing in paragraph 10.
Yes.
So let's read or go a little bit more slowly between paragraphs 10 to 30 and probably 49 to 60. So we had the introduction of King Barnes Consultants. We have the introduction quite extensively of people who are said to have been introduced through KBC, Mr. I.S., Mr. and Mrs. S. One sees at the foot of page 6, Mr. N.H., page 7. And that is difficult to square with what is said at paragraph 10, because it's a factual recitation rather than an explanation of what the breach is said to be. So this is part of the difficulties.
Well, there's a misrepresentation in paragraph 13, which of course was only known about later. But
yes,
one can see a potential cause of action in 13. But where is otherwise the wrongdoing set out?
Well, it's rather difficult because having introduced breach at paragraph 10, we don't get anywhere. Then section F is termination of employment. There's a lot of background here, and it's signally apparent that what's pleaded here is Reli, R-E-L-I, not the claimant. Then we have the letter of termination, which again has its own problems. Then we have the data breach. So before we've even worked out what the main argument is, the second argument, namely the data breach, is introduced at paragraphs 39 through to 48. We've got a separate analysis of that, which Your Honour will have seen in our skeleton argument, and we say it doesn't amount to either a data breach at all, or certainly not a notifiable data breach. I can come back and explain that in due course, should the court wish it. Then we get to breaches of fiduciary duties, acting dishonesty and attempting to onboard new clients to his employer through KB. So it is clear that this depends totally on the referral agreement, which the claim form says was entered into by the claimant. And indeed, the learned friend in his skeleton continues to perpetuate this fundamental error because he says at, I think it's paragraph 47H, is it 47H? Let me see. Yes, 47H in his skeleton argument. 47 in his skeleton argument is headed claimant's claims or seized claims, page 20. We get on to subparagraph H, top of page 22. Based on D's representations, a referral agreement was entered into between C and King Barnes, pursuant to which King Barnes would be entitled to, etc. That is not right. It was not a referral agreement entered into by the claimant. So the error, which is seen at paragraph 49, and which infects the whole of the section on Mr. Khan's breaches of fiduciary duties, is on the same wrong premise. Let's go over the page to section J, page 11 of A3, paragraph 52. In brokering the referral agreement with KB, Mr. Khan, etc. Again, the whole premise is fundamentally flawed. Then we get on to an alternative claim, paragraph 53, but this alternative, again, little c, the statement was made in order to induce, and did induce, the claimant to enter into the referral agreement. Again, completely the wrong premise. At little e, top of page 12, Mr. Khan is liable because he made representations, and little 2, the claimant entered into the referral agreement. Then there is a claim in negligence, but the negligence is in relation to exactly what has gone before. Then we get on to the losses, and that's the length and breadth of the present pleading, and that, Your Honour, is why we say we have, well, we can't go behind the allowance that Your Honour made at the outset of putting the question to me, the allowance for the inadequacy of the pleadings. So inadequate that it has to be struck out.
Yes.
So, having looked at the pleading, both the claim form and the particulars of claim, we say they have to go. On the basis that they go, there is no scope for set off. In relation to commission, which I have taken by way of summary form argument, I mean, everything else is set out in the skeleton argument. By way of commission, my client is plainly entitled to a very substantial payment. Whether termination was for cause or not for cause, that's what his entitlement is set out in the employment agreement. And therefore, we say that there should be immediate judgment in terms of liability, with the taking of accounts stood over, making inquiries and taking of accounts. And Your Lordship, Your Honour, began by saying, let's look at how we can move this along. In our submission, this is a very constructive way of moving it along. And I might say that my client certainly wishes matters to be moved along for the reasons already indicated. He is owed an enormous amount of money, and because of a defamatory letter that the claimants chose to circulate to the business partners, he's not been able to find alternative employment. Now, of course, that's a separate head of claim in relation to under the law of obligations. Again, it would form part of the making of inquiries and taking of sorry, I've got a message just flashed up on the screen, but it's now gone. That again would form part of the making of inquiries and taking of account. So I'm very happy to assist Your Honour further, but that in summary form is my response to Your Honour's question.
It's a real mess, this particulars of claim, not settled by Mr. Doherty, I see. Just bear with me a moment. Does the say again? No.
Sorry, Your Honour, I just wanted to point out that my learned friend has disappeared from the video feed. I don't know if that meant that he disconnected. No,
He's back.
No, I'm back. I was just having a chat with my co-counsel.
Paragraph 53D, Mr. Patrick Joyce.
53E.
D.
B, yes.
D for Delta.
D, sorry, yes. Mr. Khan was aware of the relationship between the beneficial owner of KB and this at the foot of page 11.
Exactly.
Well, it says that there was a relationship between the beneficial owner of KBC and the managing director of what we now know to be the Bank of Singapore.
Husband and wife, yeah.
But we know, because we've seen the response from KBC, inquiries made after the termination of my client's employment, that there was no conflict of interest. They say in terms that there was no conflict of interest.
Well, they may say that, but the question is whether or not there's an arguable pleaded case. I mean,
my apologies. I don't mean to cut across, Your Honour, but Your Honour, that arises from the claim form, which says that there was an obvious conflict of interest between the beneficial owner of KBC and her husband.
Well, I understand that. I understand that.
And Your Honour was putting, sorry, and what Your Honour was putting to my learned friend was, well, if there's any conflict of interest, it's between Mr. Sheikh, who was a senior employee of the Bank of Singapore, and the Bank of Singapore.
That's so one would think.
Yes, Your Honour, I respectfully agree. So one needs to know the basis on which the claim is put, and it needs to be put on a proper basis.
Yes. All right. Yes. Mr. Doherty.
Yes, Your Honour, I have rather a lot to say about this. I don't know if there's a question about how much of that you want to hear from me now and how much of it you want to hear at trial, because as you observed at the outset, this is a case which involves extensive amounts of disputed fact and requires a trial in order to deal with that. That's really the fundamental point. Indeed, it's somewhat telling that the document that my learned friend went to, when asked to explain why the claim had no prospects of success, was limited to a confined point in the brief details of claim, i.e. not the particulars of claim. And really the overarching observation is that what the defendant has sought to do here is build up what's frequently referred to as a straw man argument that it can knock down by trying to place at the centre of the court's inquiry this question of whether or not the referral agreement was entered into by the claimant or one of its sister companies or one of its group entities. But really that has nothing to do with the core allegations of this dispute. And I'll come on to, in as full detail as I can assist you with, all of the reasons why we say each particular head of claim is clearly one that requires trial. But even if one just starts with the particulars of claim.
Well, let me stop you there for a moment, Mr. Doherty. Do you accept that your case needs repleading?
No, I'm not sure I would go so far as to say that. Could it be pleaded differently? Could it be pleaded more clearly? Perhaps that's one question. We don't say that the claim as currently pleaded is in such a state as it could be struck out, and I can take you through the particulars of claim as to why I say that's the case.
Do you accept that it needs amendment?
If Your Honour considers that amendments will put the case in more clear terms, one can do that. Certainly, we can go and take away, and we can look at that point. But I think that we need to address the application that's before, and what we say is a not entirely fair representation of what the currently pleaded case says, because it is not about the act of entering into the referral agreement and who those parties were, but the facts that have already been pleaded disclose causes of action far beyond that. So we say that the pleading can stand as it is now. Does it have more chances of success if it's repleaded? Perhaps. Will, after this hearing, or in the encouragement of Your Honour, agree to directions where we do replead it? Certainly, if that's going to enhance our case. But really the fundamental point is that we say is it cannot be struck out on that basis.
Well, can you then take me to what you say is the wrongdoing that is complained of in the claim form and the particulars of claim? One obviously reads the claim form in the light of the particulars of claim.
Yes, of course. So if one starts, we've got the introductory paragraphs. I'm looking at the particulars of claim now. We've obviously got the introductory sections.
Yeah. Well, there's nothing that's relevant until you get to paragraph 10, where there's simply a plea of breach. Well, without saying what it is.
Not quite. From paragraph 10, we certainly get the factual premise on which breaches are argued. But what we also have is paragraph 6 on page 2, which sets out the contractual obligations.
Yes.
Which are said to have been breached as a consequence of the factual circumstances that follow.
Yes, but just look at those for a moment. In signing the declaration, I'm looking at J. In signing the declaration, he undertook to take all reasonable steps to ensure that conflicts of interest were identified and disclosed. And so one then is looking to see where's the breach in not disclosing a conflict of interest, and then secondly to disclose to his employer his business interest with third parties. And one looks then for the question of where is the business interest with a third party that hasn't been disclosed. And I'm asking you therefore to take me to the breaches as opposed to the duties that are alleged.
Yes, although it's important to point out, Your Honour, that the breaches are not simply what's said out of J. It's also this issue with the diversion of business, with taking steps that negatively affect the company's reputation and so on. There are a whole host of contractual breaches that are relied upon rather than simply what arises from the declaration.
Yeah, well, I understand that, but I'm looking at this document to see exactly what is said to be the wrongdoing. I have problems with your pleading. When I read this document, I struggled to understand what it was that exactly was being said. It was only when I read Mr. Chin, and having stopped and thought about it, having read your pleading as to what I thought you must mean, it was when I read Mr. Chin, I said, that's what that's what the case is really about.
Yes, Your Honour. Well, perhaps let me break it down. I think it's important to explain what the case is and what the factual and legal premise is. So I'll take a little bit of time to do that.
Please.
I'd attempt to do it in my Skellen argument as well, but stepping back slightly, the claimant and its group entities place insurance policies to high net worth individuals. And the way the business model works is that the claimant, the Middle Eastern entity, markets and sources referrals within that region using a number of its referral sources. So that's banks, financial advisors, and so on. and other group entities then broker the policy with the insurer. What that generates is referral fees, which is where the claimant's revenue comes from. So one can see, based on that business model, why it's reliant on its referral sources, and why for the business model to work, in effect, its reputation and its relationships with its referral sources are pretty important to its profitability and its bottom line. Now, the defendant is employed to assist with that activity. He's paid by reference to the commissions that are received out of those transactions and for policies that are placed. And the relevant chronology which gives rise to this dispute really starts in April 2022. That's when the defendant begins this process of placing a policy with Mr. Sheikh. So this is the BOS director, or the managing director of the Bank of Singapore. I understand.
Mr. Doherty, I'm sorry to constantly interrupt. I understand exactly what it is that's being said, but what I'm looking for is what the pleading says. I'm trying to find a way through this case that brings us to what is truly in dispute, to have the matters properly set out and to eliminate all that's irrelevant. And what I need to know for these purposes is whether your particulars of claim, as currently pleaded, do enshrine a case that stands up, or whether in fact you have to amend it, or whether it ought, as Mr. Patrick Joyce says, be struck out because it doesn't disclose a proper course of action. I fully accept that Mr. Chin says things which justify the stance that you're putting forward. But the question is, do I find any of that in this pleading?
Yes. Well, Your Honour, that brings me on, I suppose, to what is the first act or omission that gives rise to the pleaded case. So it's paragraph 12 of the pleaded case, page 11 of the bundle.
Yeah.
And it's this email from the 19th of July.
Yeah, there's a misrepresentation. Yeah. This
is Mr. Khan's misrepresentation, the lie that we say he subsequently called in when he says he's just met the owners of Kingsbarns. They've been referred by, it's the ciphered name there, it's Omani Wealth.
Yeah.
So that's the factual premise number one. We've got the introduction of Kingsbarns based on a false premise, which is what ultimately leads to the instruction, the due diligence, etc., behind entering into, by a related entity, this referral agreement. What we then have pursuant to that introduction is a series of transactions where KB, Kingsbarns, is cited as the referral source. And there are problems with each and every one of those referrals. So we've got the pleading about Mr. IS, that's paragraphs 14 to 22. Now, the problems with that, of course, are that the referral source is owned by his wife. Yeah. And that's the information that's not being disclosed by the defendant, which we say is obviously relevant information. And the fact that not only has he not disclosed it, but because he has actively lied about the origin of his introduction to Kingsbarns, is the dishonest conduct on which he was dismissed, and is the dishonest conduct which give rise ultimately to the claimant's financial losses. And there are, as one can go through the facts, I can go through them if you wish, but there are various other dishonest statements within this. So, for example, in the context of this particular transaction, what we have from Mr. Khan in the evidence before the court is an email he sent, which was a draft letter to the insurer, in which he represents that the insured, Mr. Sheikh, has been known professionally to Kingsbarns for a period of 5 years. And that's the representation being made to the insurers off the back of what Mr. Khan has told the claimant. Now, there are a host of reasons why that can't be true, not least of which is the relationship between Kingsbarns and the insured, but also the fact that Kingsbarns was only actually set up about a month before, in June 2022, when these transactions were being contemplated. So that's a broader background to what will come out at trial, but is already in evidence. If we then go down further in the pleading, we've got Mr. and Mrs. S, the second set of transactions. And the pleaded facts behind those. And again, those include those representations about having known them professionally for a period of 5 years, which again, we say can't have been an honest statement from Mr. Khan. He must have known that that wasn't true. But nevertheless, what we know about Mr. and Mrs. S is that Kingsbarns itself has subsequently written a letter saying that they disown those transactions and that they never referred those parties to a policy. So again, we have another instance of a policy being generated based on false information being provided by Mr. Khan. And then there's Mr. NH, paragraphs 28 to 30. And the particular issue that arises from this transaction is we have a scenario where we have an individual who has cited as a referral source the Bank of Singapore, and that he then, via Mr. Khan, changes the name of his referral source to Kingsbarns, so that referral fees that would have gone to the Bank of Singapore, i.e. a long-standing client or a long-standing professional relationship held by the claimant, would end up losing money, and the money would be going into the pockets or the coffers of Kingsbarns, which we say is the conduct which is diverting business away from referral agents used by the company, and that's what ultimately causes the discontinuance of a professional relationship and therefore loss of revenues. So again, that's the factual background.
Can I just stop you there for a moment to examine the position? If an individual such as a senior employee of the bank chooses to seek insurance through any agent, whether related to him or not, is there any reason why you shouldn't do that?
Well, one can see the clear risk or the clear legal risk in that sort of transaction. That's the sort of risk which in the UK one might see as treading into the sphere of, to use a colloquial term, kickbacks or bribery or some other form of legal conduct. Now, I don't profess to know what the position is in the relevant jurisdiction here, but it was clearly potentially material information, and information which Mr. Khan saw fit to conceal from the claimant, because he never brought it up, and he lied about the origin of the introduction to Kingsbarns because he said they were referred by Amani Wealth, which wasn't true. So
well,
clearly
I understand the misrepresentation point as to the recommendation, but I'm just trying to look at it from a starting point. If any individual seeks insurance, on the face of it, they're entitled to go to any person who can refer them to a broker or to an insurance company. I mean, you know, solicitors, accountants, banks, they all do it. Someone goes to their solicitor, their accountant, their bank and says, I'm thinking of getting insurance. Where do I go? And they make...
Sorry.
So, Mr. Pratchett-Joyce, I think...
Sorry, I turned my camera off because I didn't want to vibrate whilst I was writing, and unfortunately I'd left the mute unmuted. I will mute myself as well.
Thank you. On the face of it, I see no reason why any person contemplating insurance isn't entitled, whether or not in the past they've used their employer, in this case the Bank of Singapore, as a referral agent, why they shouldn't use someone else, even if that person is related to them. Of course, it may be different if there may be a problem if the employee in the position of the defendant here hides the fact that something is going on and himself is taking a kickback from the new referral agent. But I mean, I can't see a problem in the first place about the managing director necessarily using Kingsbarn consultants in itself. And I'm trying to just ascertain whether I'm missing something there.
Yeah, sure. Well, I think there are a few points built into that, which is, one, is there some form of suspicious or notifiable activity involved in offering the beneficiary of a policy an ancillary benefit by entering into that contract by giving a proportion of a commission fee? That's one question. The second question is, ultimately it's the insurer that's going to be paying this. And one wonders what the insurer would think if no referral had in fact been made and the referral fees that had been paying out were actually going straight back to its customers. There may well be contractual questions about what that does to a policy and so on. And then there's the third category of problem which arises in this instance, which is leaving aside Mr. Sheikh's own policy or his wife's own policy, given that she was a beneficiary. There's a question about steps being concealed and being undertaken, which negatively affect the pre-existing business relationships of the claimant, causing discontinuance. And the particular problem here, indeed the problem that ultimately led to the dismissal, was this individual who transferred his referral source, which had previously been the Bank of Singapore, to Kingsbarn. And what that means is that a long-standing and trusted professional relationship has seen fees that would have otherwise been going to them diverted elsewhere, and that causes obvious reputational risks for the claimant. And really, it's that more than anything which has caused the financial loss in this case, because that's what we say leads to the withdrawal of Bank of Singapore's business.
Yes, can I just focus on the point as to the wife? The wife both owns Kingsbarn Consultants and is a director or whatever of it.
Mm-hmm.
She is also a beneficiary under her husband's policy.
Mm-hmm.
And that is not being disclosed.
Yes, it's not been disclosed until it's been flagged by another employee of the claimant when the passport details have been sent through.
Yes.
There are also issues, I should say. So, for example, I referred, Your Honour, to the draft letters that went to the insurer earlier in respect of some clients. And what those letters said in respect of Mr. and Mrs. S were, these have been referred by Miss Niazi, i.e. the wife of Kingsbarn's consultants. I've known them for 5 years. When it comes to Mr. Sheikh, her husband's policy, that wording has been changed by Mr. Khan to say Miss Manahill. So on our case, there's a reason those names have been swapped out, because he knew it would have triggered some kind of issue. And again, that's part of the concealment that we're talking about.
Yes. But I mean, I understand all these points, but the real question I have is looking at the pleading as it stands. You've taken me so far to, I think, paragraph 30.
Yes.
When one comes then to the plea of what the wrongdoing is, I don't think I ever see it put in the terms in which you have been putting it today, or indeed Mr. Chin has been putting it.
Yes, I'll take Your Honour there, or at least as to how, in my submission, the particulars of claim reads. I'll skip over the next section. That's about the termination of employment, and really the crux of that is, because of this fact pattern above, what we've just been discussing, and because of your dishonest conduct, you were dismissed.
Well, 36 is important, isn't it? 35 says repudiatory breach. Whether that's correct expression as a matter of DIFC law is neither here nor there, but
yes,
he's in substantial breach, which entitles termination and summary dismissal. And then you've got, in particular, we've got the false representation of Kingsbarn being referred by Imami Wealth.
Mm-hmm.
And then you've simply got Mr. Khan's actions amount to willful misconduct, etc., without specifying what those actions are.
Yeah, sure. I think that paragraph is intended to be viewed in light of the pleaded facts in the preceding paragraph. So that's in light of his conduct in bringing about these transactions. But ultimately, it's a question of his dishonest conduct, which we would say is ultimately a matter for trial. But the crux of the point, the rationale or the reason for dismissal, is you've been dishonest, and that's a breach of your relationship of trust and confidence. So that's the implied duty in your contract, but it's also 36B, a breach of express contractual obligations in your contract of employment, and that's why we've dismissed you. And the question that then arises from that on the defendant's case is whether or not that's a reasonable dismissal for cause pursuant to the employment law. But again, what that involves is the court examining what was the actual reason for dismissal. Was it arbitrary, as the defendant says, or was it based on the facts pleaded by the claimant? And ultimately, and I can come on to this in more detail in due course, we say that that's a factual dispute, which is going to need to be resolved by the court because of the distance between the parties. But that section really is addressing the reason for dismissal, which is more relevant to the counterclaim than it is directly to the claim, if that makes sense. It anticipates the counterclaim, I suppose I could put it that way.
Yeah.
We have the further pleading. So the data breach is really about the factual background to the retention of particular documents by the claimant, which is relevant in the context of his confidentiality obligations pleaded at clause 6 of the particulars of claim. We've got the later events, which again, these are factual pleadings, which I don't necessarily mean to go through. One point, just to respond to what my learned friend said about, we've got this letter from Kingsbarns in which they categorically say that there is no conflict of interest. Of course they say that. That's not really the issue. It's not determinative of the issue in any way. The question is, looking at this transaction, as will happen in due course, one hopes at trial whether or not that conflict existed and ought to have been disclosed, or whether it was concealed. It's from section I then that we really get to the summary of the pleaded wrongdoing. So paragraph 49, for the reasons set out in paragraphs 10 to 42, i.e. based on the factual assertions made above, here's what we say the legal effect is. And first of all, we've got breach of fiduciary duties. So we had the pleading of what those fiduciary duties were earlier. I think that's paragraph 7 and 8 of the particulars of claim. Let me just check I've got those references right. Yeah, so paragraph 7, 8, and 9. We have the pleading pursuant to Article 158.
Yeah.
The defendant, his capacity of employees, owed these duties, good faith, etc. It's those matters that are set out in Schedule 3. So one also needs to view this paragraph 49 in light of what those pleaded duties are. And what we say is that those duties were breached because, and this is really the fundamental point which undercuts what I described as the straw man relied on by my learned friend, because this isn't about any direct contractual relationship being entered into by Relly, Cayman and Kingsbarns. The breach of fiduciary duty here is because the defendant has dishonestly attempted to onboard new clients through Kingsbarns. And the reason that was a breach is because he acted dishonestly and wrongfully by misrepresenting the referral source. So that's the Imani Wealth email, by omitting to inform his employer about the fact that Miss Niazi was Mr. Sheikh's wife. C, attempting to onboard 4 clients in light of that conflict, and what's referred to as the conflict of interest there means, at least in one case, the fact that funds which would have gone to the Bank of Singapore are being diverted to another agency. And then we have reference to the data breach in that context as well. So that's not protecting confidential information that he acquired during the course of his employment.
Where is the wrongdoing relating to Mr. and Mrs. X? apart from the misrepresentation of the recommendation of King's Barn. Looking at paragraphs 23 to 27.
Well, let me just go back.
I'm trying to relate 49C to paragraphs 23 to 27.
Yes, Your Honour. So the facts there are pleaded in paragraph 46. So on or about 29th September, KB responded stating there's no potential conflict of interest. And then and that the insurance policies B and C were not referred by them. KB gave notice to terminate.
Yeah, I'm not understanding that.
Pardon?
I understand the point about
Yes.
conflict of interest in relation to Mr. Sheikh and the Bank of Singapore, Mr. Sheikh and his wife as the beneficiary of the policy. I understand all of that. I understand the point in Mr. NH's case, who previously had a referral, and there's a switch of referral, and it looked odd. But for so far as Mr. and Mrs. S are concerned, who simply on the face of it use the referral agent of King's Barn, leaving aside the misrepresentation as to King's Barn being recommended by Emami Wealth, where's the wrongdoing in context of their policy?
Yes, Your Honour, I understand your point now. I think the simple answer to that is that the transactions which invoke the breach are the first and fourth, effectively. The second transactions were, at the time of pleading context, and at the time of dismissal, it wasn't actually known that King's Barns were disowning those. The claimant doesn't have any more information about why King's Barns disown those. It may well be that more information comes out during disclosure about that particular transaction, and it may well be that a consequence of that necessitates an amendment of the pleading to include that there was a further breach in relation to that transaction. It wasn't pleaded because I don't think that at the time the particulars of claim was drafted, anything was known about the circumstances surrounding that transaction. So that's the short answer to that is it's not relied upon as being the breach of fiduciary duty. The breach of fiduciary duty relates to if I can put it this way, the wife conflict and the diversion of business conflict.
All right. Then if one goes on,
yes,
into your paragraph section J,
yes,
where there's the misrepresentation, you accept, I take it, that paragraph 52.3, 53C, and 53E2 wrong insofar as the referral agreement is not with the claimant, but with the Cayman Island company,
yes,
which entered into it, no doubt, on the basis of instructions from both Hong Kong and the initiation of business from the Middle Eastern company. So that in itself, to reflect Mr. Chin's statement, would have to be the subject of amendment, wouldn't it?
Yeah, so it would be an amendment to say that it caused the agreement to be entered into effectively. The point we made about that in my skeleton you'll have seen is that it doesn't actually, it's a distinction without a difference insofar as a deceit claim goes, because the factors that need to be established are that there's a fraudulent statement, which is what's alleged, that there was an intention that the person should rely on it, which again is what we say Mr. Khan intended, that it was relied upon, and here it was, because it's led to the claimant carrying out its due diligence procedures and causing the agreement to be entered into. The point is that in order to make out a case in deceit, you don't have to show that the claimant itself entered into the contract, so long as it caused the contract to be entered into and it suffered loss as a result. So yes, one accepts that the factual pleading there can be changed, but that the underlying basis for the cause of action is the same, which is the defendant made these fraudulent statements, which we've gone through in relation to these transactions, and it was those statements which brought about the harm.
Yes. Now, so far as the harm is concerned, moving on to an entirely separate topic, loss of reputation, is that a recoverable head of damage under the law of DIFC?
It's not a loss of reputation that we are relying on. The actual piecing together of what this meant for the claimant's bottom line is going to have to be a matter for evidence, and in all likelihood, it's probably going to be expert evidence. But the fundamental point is that the way in which the claimant is paid is directly by reference to fees paid out by the insurer. So it gets 28% of those net fees. So if you have clients who leave because one of your employees has acted in a particular way, that leads to a direct loss of revenue. So we're not saying that it's not as Willie is saying as our reputation in the market has been diminished and therefore our overall revenues have gone down. What we're saying is specific revenues from specific banks has gone down as a direct consequence of this individual's actions. And I think beyond that, really, that gets into, if the defendant wants to raise the point, I think you get into arguments about remoteness and things like that.
Yeah.
But those are factual issues, and it will be for the claimant accepts it will be for it to establish that these aren't losses which are too remote so as to be recoverable.
Well, it's paragraph 65 to 73, isn't it? Loss of income.
Yes.
I'm uncertain whether paragraph 66 is saying that the Bank of Singapore simply has made no more referrals at any stage and has stopped making referrals as a result of what's happened here. But certainly so far as Hydra and Gorgon are concerned, the other two banks is Mashreq and I can't remember which other bank it is.
NBD, I think it is.
Yes,
Emirates NBD.
Yes, Emirates NBD. So far as they're concerned, it's saying less business rather than total cessation of business, I think.
Yes.
But it's not saying expressly that each of the banks has said in terms we will not do business with you anymore. Is that right?
That's my understanding, and ultimately that's going to be. I mean, really, it's a causation issue, isn't it?
Yeah. It's obvious. It's obviously presents difficulties of proof, which would require both factual evidence and expert evidence to establish any actual loss of business and loss of profits.
Yes.
Yeah. But you say the plea is adequate, do you?
Yes, I mean the precise figures are obviously going to need to be further particularized in due course, but the fundamental point is there, which is that this action caused a direct financial loss, and that's going to have to be articulated by, as I say, likely an expert review of the income that came in before and what happened immediately after. That's what the evidence is likely to look like in this case.
Yes. All right. Okay. Well, that's been through your pleading.
I should say we've obviously, of course, got beyond that. So again, based on the same fact pattern, their allegations of negligence. Again, I make the point of my skeleton, and when one looks at Article 18, and you're talking about proximate relationships, whether a duty is owed, what the scope of the duty is, whether it's breached, you're looking into an investigation of the surrounding circumstances more often than not, which really is a matter for trial. But I suppose the fundamental point is that there's no inadequacy in the pleading of that case. We rely on Article 18 of the Law of Obligations. We say that that's what's been infringed based on the same fact pattern as sustains the fiduciary duty claim, the contract claim, and the deceit claim. And the, I suppose, the precise, as I say, scope of those duties, whether they've been breached, is going to have to be a matter of both witness evidence in due course and then ultimately legal argument that arises from whatever those witnesses say. But I do note, certainly insofar as the existence of a duty of care as between employer and employee, my learned friend has in fact put into his skeleton argument an express reliance himself on Article 18. I'll come on to that in perhaps a little moment when, if Your Honour wishes me to deal with the other aspect of this case, which is the counterclaim and some of the issues that that throws up. But what that appears to acknowledge, at least from a learned friend's perspective, is that there is obviously a reasonable ground on which to say that a duty of care as between employer and employee exists. And really then it's a question of fact as to whether it's been breached.
Yes. All right. Well, I think the question then is where we go next. There's nothing else you want to say about the pleading point as such?
No, I think that probably suffices for now, unless there's anything I can assist with. I suppose the takeaway point is that we say that even if one could point to it and say it's not a perfect pleading, the core elements for sustaining the cause of action are there, and that we readily accept that there are particular factual points which would need to be changed, but that the claims don't stand or fall necessarily based on that amendment, because the causes of action don't require the existence of the contract. It's the surrounding circumstances that have been relied on already.
Yes.
And it may well be that the most sensible way of addressing those are suitable directions at the end. But certainly what we say is that when one is, I don't propose to take Your Honour to it in any great detail, the Justice Giles' recitation in JFH is cited before this court probably more than any other authority. But these are,
you can assume I'm familiar with all of that.
Ultimately, this isn't a strikeout case. There's too much. I mean, it's one looks at the hundreds of pages of witness evidence, documentary evidence, arguments that have been placed before you, and one can form a view on that pretty much straight away.
What I'm thinking of doing next is taking a 5-minute break. But following that, unless either of you have any better ideas, I'm going to invite Mr. Doherty to deal with his application, and then allow Mr. Patrick Choice to deal with both that application and anything further he wants to say in reply in relation to his own application. And then finally, Mr. Doherty can respond if there's anything to be added in relation to his applications. You follow?
Yes, I understand, Your Honour. Can I check whether you want me to say anything about the counterclaim? Because I obviously have dealt with one aspect of the defendant's application, but he's seeking to strike out both our claim, but also judgment on his own counterclaim. So I'm conscious I haven't necessarily gone through that in detail, but it may well be that my submissions have covered the territory you need.
Well, I think there's a practical question, isn't there? Regardless of whether you're right or wrong in relation to the strikeout of your pleading, does it make sense in any event for an account to be taken in relation to the commissions? So you may want to deal with that. I mean, there's no question that subject to set off, there's some commission due. The only question is how much. I think you would accept that, wouldn't you?
Well, not quite. We say that there are construction points. There are also, I can take you through what we say about the commission structure and why ultimately this all needs to be held off to trial in any event. But I'm also conscious that the defendant's counterclaim isn't just about commission. It's about victimization, discrimination, breaches of the regulatory law, a brand new allegation reflected on by my learned friend is skeleton of apparent libel. I'm not sure what the legal basis for that claim is, but
well, there's no definition taught in DIFC, is there?
Quite right, and the industrial group makes clear that you can simply import common law concepts in. But I suppose the broader point is there are an X number of allegations, some of which clearly cannot.
Mr. Doherty, I want you to deal with your your strikeout point in relation to victimization and racial discrimination and so on.
Yes.
But in the context of Mr. Patrick Joyce's claims, it's inevitable that there is some commission prima facie due, subject to whatever your claim may be. There may, as you say, be some arguments about particular aspects of it, and a figure has been arrived at by one of your witnesses, I think, of around $865,000 US dollars or something, if I've got that right. Mr. Patrick Joyce and the defendants say it's running into the millions, but the question I have is, does it make sense for at least that figure to be quantified earlier rather than later, regardless of whether liability is actually established, because it's a matter that obviously is going to have to be resolved in due course.
Yes, I think I understand that now. Really, it's should work be put in now to determine what quantum is, without assessing anything to do with liability.
Yeah, it's assume on the assumption for the moment that liability has to await another day. So I'm going to take a 5-minute break, so you can then address me on those points and on the points you want to make about victimization and discrimination.
Certainly.
And then Mr. Patrick Joyce can respond on all fronts if he wishes to. And I'll give you a final word in relation to your own application.
Your Honour.
Does that make sense?
Yes, and speaking for myself, I'm very much obliged that I have the right to come back briefly on all fronts, because there are matters arising from what the learned friend has just said that are in dispute. Thank you.
Yes, right to reply on your own application. It's always the case.
Thank you.
And normally I don't stop people from coming back even beyond that, as long as they're not simply repeating themselves, if they've got something new to say.
No, it was simply a matter of convenience, Your Honour, as to whether it was now or at the end, but at the end is probably much better.
Let's see where we go. I'm just going to get myself a cup of coffee, so we'll have 5 minutes. Thank you very much.
Thank you, Your Honour.
Are you all set, Mr. Doherty?
Yes, Your Honour.
Thank you.
I think the place to start may well be looking a little bit more at what the contract says about commissions, because we've already looked at the provisions of the main body of the contract, which set out the 4, I suppose, conditions precedent to the payment being released. The actual process of calculating what the commission is actually set out in. It's a little bit more complicated than that, if I can put it that way. So if we go to page 929. You should have a document. I think it's quite slow to load, but it says Exhibit B. It's part of the contract, but it's the commission schedule.
Yes.
So you obviously have the conditions for release that are in the contract, so the satisfaction of the criteria, which includes it actually being paid by the insurer, as well as the fact that commissions are released at the end of the year. And then Exhibit B, just following it through, so the first paragraph refers to earned commissions being paid based on the net revenue received by the company from the sale of the jumbo life insurance policy. The net revenue consisting of the gross commissions less the referral fee.
Yes.
Now, just as a starting point, it's not entirely clear from the counterclaim what the figures set out by the defendant are supposed to be. It's unclear whether he's saying that these are the total gross commissions in respect of the entirety of the claimant's business, or whether they are the net commissions received by the entire business after referral fees have been paid, or if what he's in fact saying is these are the net commissions which relate specifically to me. It certainly doesn't seem to be the latter, because the figures he says come from one of the company's interim reports.
Yes.
What is clear is that what's being claimed in this case by the defendant is some 8 times more than anything he's ever received in another year. So one suggests that the premise in which he's got his figures is not necessarily correct. But anyway, what this commission policy is telling us is, in order to get to an entitlement to commission as the employee, step one is you take the gross commission and you take off the referral fee.
Yeah.
Then at paragraph 2, you've got certain jumbo life insurance policies with enhanced cash values pay commissions over a deferred period, and only the first year commission is used to determine the net revenue amount. So what that's saying is you have to then determine what type of policy it is and how the commissions are paid out by the insurer, because what seems to be the case there is that for particular types of policy, you effectively amortize the commission that would be payable. So you're not getting the whole of the value of the commission in one chunk. You're getting it spread across a period of time. So you have to work out which policies are enhanced cash policies and which are not. Then paragraph 3 is stated in this agreement: the net revenue used to determine your own commissions will not include any case where the gross commissions are less than $40,000. That's because the policy of the business is that they are selling these jumbo life insurance policies. So if it's too small, you don't get entitlement to commission. So whatever your total sales are for the year, you have to take off any commissions received that don't fall above that threshold. And then once you get there, you have a schedule which shows how much you're entitled to. So you've got different bandings where you get what the minimum payment would be under those bandings and a particular percentage on top. So you've got to work out what banding you fall in at the end of the day, and then you've got to apply that percentage. And then below that, so 2 paragraphs below where the table is set out, says your earned commissions will be adjusted to determine your net commission revenue. Net commission revenue is your earned commission minus extraordinary expenses. And then minus any, this touches on a point you raised earlier, Your Honour, and minus any pro rata chargebacks described in this Exhibit C.
Yes.
Well, on chargebacks, there are a couple of points. I think what was being discussed earlier or contemplated earlier was where you have someone who withdraws the policy during the cooling off period. So in that case, one would expect that you don't have any commission. With insurance policies, I'm sure Your Honour is familiar. I mean, if I cancel my car insurance 6 months in, I'll get a pro rata reduction. So you then need to work out if there are any of those policies and whether there need to be a pro rata clawback of commissions that had previously been paid.
Yes.
Following which, next paragraph, your net commission compensation will be paid at the end of the calendar year after adjusting again by reference to your annual draw. So that's the upfront amounts towards commission that you are paid. And ultimately, you end up being paid out only if you're above your draw threshold.
Yes. Well, Mr. Chin calculates about 685,000 max, doesn't it?
Yes, well, that's what he says. I don't know that there is any precise arrived at figure of what it would be.
No.
Of course, there are other problems which tie in with how the dispute's resolved. Obviously, set-off's one of them. I won't go to that because I think you have that point. But there's also, for example, arguments that are going to need to be had about, to list a few. One, what was the date of termination? Because that's obviously going to be relevant as to whether a commission that, for example, may have been negotiated or some of the work may have been put into, let's say, in June or July, but the insurer only pays post-dismissal within the, let's say it's paid within the notice period under the employment law. The question is going to be, is that commission due? And that is largely going to turn on the question of whether or not the defendant is dismissed for cause. Because if he's dismissed for cause, he's entitled, on his argument, which we don't accept, to his commissions up to the 14th of September. on his argument, he's entitled to commissions which were received 30 days before that, 30 days after the 14th of September. So until trial, we don't really know what that date is going to be. One can see a host of other arguments that are going to have to be had by entitlement. There's the argument which the claimant will rely on to say that his commissions were only payable in line with the norm at the end of the year, and his entitlement hadn't fallen due at all by the 14th of September, so he's not entitled to it. But even if one assumed that argument is incorrect, we still are going to have arguments about what would happen, for example, if you have work undertaken on a particular policy prior to the date of termination, but after the date of termination, the payment events crystallize, i.e. payment is received from the insurer. Is there any entitlement to those sums or not? That's going to have to be dealt with on legal argument based on what the proper construction of the commission terms of the contract are. And really the fundamental problem is that we don't know really much about what is being claimed by the defendant. Like I say, we don't know if it's gross or net commissions that he's setting out. We don't know what deductions need to be made for particular referral agents. We don't know whether the deals that he's referred to in his counterclaim have actually anything to do with the defendant rather than any other employees. And there may well be factual arguments about who's entitled to particular commissions. We don't know which policies have enhanced cash values. We don't know how many of the deals fall below the jumbo threshold. We don't know if the claimant has received payment from the insurer in respect to specific policies, in part because Mr. Khan doesn't say, I negotiated X deal, Y deal, Z deal, and I'm entitled to commission on those. We don't know what precisely he's saying he's entitled to and what he isn't. Now, how does one resolve that? Well, we say that simply just falls into the normal process of preparing for a trial in precisely the same way as the claimant is intending to articulate its own losses in due course. So it's a matter of requesting and disclosing relevant documentation. So that will be presumably financial information, information relating to deals that have been entered into, information relating to the defendant's involvement or not in those deals. After that, one can expect there to be some particularized assertions from both sides as to what, even if one assumes liability is accepted, the proper quantum should be based on the various construction arguments, based on the various potential factual arguments that arise in relation to date of termination and so on. And ultimately that can then be covered in, amongst other things, disclosure, witness evidence, if required, expert evidence. And that's part of the normal process of trial. And that's the information that Your Honour or whoever hears this matter in due course is going to have at trial. And so we say, quite simply, that's the appropriate way of dealing with it. It's far too early in proceedings to be adopting a course which is out of the ordinary.
Yes.
And so that's what I mean to say about commissions. And obviously, ultimately, it's for the defendant to prove his claim. He'll have the documents and the material to do it, and he has to do it. Like I say, there are points that I can make, but I won't unless you specifically want me to, on these purported claims for libel, breaches of the regulatory law, on the counterclaim in relation to entitlement to notice, which we say falls in with whether dismissal for cause was reasonable or not, factual dispute. The question of set off, of course, the expenses claim, and so on. Or I can simply move on to the victimization and discrimination points that form the part of our application. I'm happy to adopt a hybrid and give you the headline points on the others.
Well, very, very briefly, I mean, there's no claim for defamation actually made in the defence and counterclaim in any event, is there?
No, there's not. It's a, well, yes and no. This is what my learned friend says in his skeleton argument, paragraphs 94 to 96. So what he says is that the claim for damages for loss of reputation, which in fairness is quite a substantial claim, he says that that's premised on actionable defamation and libel, which in turn he says arises out of Article 18 of the Law of Obligations, which it doesn't. Article 18 is about negligence. We say it's quite an extraordinary submission, but it's also not pleaded, and so doesn't require, in my submission, much oxygen to deal with. That's clearly not something that is maintainable by the defendant, let alone something that can be entered as judgment summarily against us. The regulatory law.
Well, I understand two things to be the position. Well, three things. First, that we're proceeding on the basis of the pleadings, albeit amplified by anything in the witness statements.
Mm-hmm.
Secondly, I don't understand there to be a tort of defamation in the DIFC at all.
No.
And thirdly, I don't understand loss of reputation to be a recoverable head of damage, save in defamation in English law, and in peculiar circumstances relating to checks on the other. That's my basic understanding of English law, and therefore the points don't arise in this context in this case.
Yes.
So what we're talking about, in essence, is the pleaded claims, which are for employment benefits, including commission and expenses, on the one hand, and your claim on the other, and the issues of victimization and discrimination that you're about to come to, and the unnecessary pleas, if I can put it that way, which you also seek to have struck out.
Yes, I think there's also, just to add to that, a purportedly pleaded case on the regulatory law.
Yes.
Which again we say obviously can't be a matter for summary determination because, in fact, the defendant doesn't have standing to bring that sort of a claim because he's not the DFSA, and he's also not a customer of a DFSA authorized entity that has entered into some kind of transaction that he now says is missold. So yeah, that's clearly not something that he can get judgment on today on any analysis. On the employment claims, like I say, the question surrounding termination and entitlement notice, you have those points. Fine. With that in mind, I'll turn to the victimization, discrimination claims.
Yes.
And then I'll touch briefly at the end. You've heard a lot of the relevant submission on that already on the abuse points, which may or may not be informed by your decision on privacy anyway. As we say, these, by contrast to the defendant's applications to strike out, actually relate to fairly narrow points of law. They're within the scope of what traditionally is seen as an appropriate sort of point for summary determination. So on discrimination and victimization, the relevant bits of the employment law, which I'll ask you to look at first, are page 1411.
Yeah.
So this is Article 59 dealing with discrimination, first of all. So Article 59, employer must not discriminate against an employer regarding employment or any term on grounds of, and the relevant ones I think here are presumably race and religion, so C and G. And if we go down, we find what constitutes an act of discrimination being further defined in Article 59(2). So it's at A, an employee being treated less favourably than another is or would be treated in the same circumstances, or put at a disadvantage, not faced by others, because of a prohibited ground in Article 59.1. So on the basis of them having a protected characteristic. The other one, which is potentially relevant, I think, is C, which is where an employer engages in unwanted treatment or conduct related to one of the prohibited grounds, which is the purpose or effect of creating an intimidating, hostile, degrading, humiliating, or offensive workplace, or violates an employee's dignity. And so, pausing there just to highlight the use of the words because of and conduct related to, which I'll come back to. But if we continue, victimization, I think if you go to the next tab, is the full provision. So page 1414 at the bottom of the page.
Yeah.
So Article 60, subsection 1, an employer must not victimize an employee. And then 2, for the purposes of this part 9, an employer victimizes an employee if it subjects the employee to a detriment or dismisses him because the employee does a protected act, or the employer believes that the employee has done or may do a protected act, and each of the following is a protected act. So A, bringing proceedings under part 9, i.e. bringing proceedings relating to discrimination, giving evidence or information in connection with proceedings under part 9, so again, providing information in relation to some discriminatory conduct, doing any other thing for the purposes of or in connection with part 9, so again, that has to be connected to some complaint about a protected characteristic, and making an allegation that the employer or another person has contravened this part 9. And subsection 3 probably isn't relevant in this case. So the victimization jurisdiction, the reason it exists as a potential head of claim, is there to protect those who are in employment, who wish to bring claims or complaints against their employer about discrimination. So what victimization prevents is an employee who's made a complaint of discrimination, whether before court or in some other way, or supporting that claim, it's so they can't be dismissed or so they can't be treated unfavorably purely as a consequence that they've made that sort of complaint. And then if we scroll down to page 1415 to Article 61, with some more general provisions about complaints under Part 9. For example, subsection 1 says the burden of proof is on the complainant, but then the most material one is subsection 2, which says that a court shall not consider a claim under this Part 9 unless it is brought to the court before the end of the period of 6 months, beginning with the later of the date on which this law comes into force, or the date of the act or failure to do something to which the complaint relates. And on the latter point of that, the failure to do something, we get some elaboration at subsection 3, which says for the purposes of Article 61.2a, conduct extending over a period should be treated as done at the end of the period, and a failure to do something should be treated as occurring when the person in question decided on it. So when they made their decision not to do anything. So pausing there, if you have a claim under Part 9 for discrimination, you have to bring it within 6 months of the act you're complaining of, or if it's an omission, within 6 months of the date of the relevant person at the employer's failure to act. Those are provisions which are clear and specific. They're also mandatory, noting the use of the word shall, and are not qualified by any other provision of the employment law, which is what the defendant precisely tries to do. They rely on Article 10 of the employment law, which sets a general time limit for complaints within 6 months of the act or within 6 months of dismissal. But the defendant really doesn't address the problem that arises with that submission, because Article 10 specifically says that it is subject to Article 61(2). So in other words, the general statement of time limits set out in Article 10 doesn't apply to Part 9 proceedings. The time limit that applies to Part 9 proceedings is what is set out in very, very clear terms in Article 61(2). And the only real answer offered by my learned friend to cut against that point is that he says, well, discrimination is serious and clearly a longer limitation period would be justified. First of all, it's difficult to understand why there should be any justification for doing anything other than what the legislator clearly intended. And the legislator's intention was clear that you can't just put acts of discrimination on ice for an indefinite period of time only to bring them post-dismissal. That's in fact precisely the reason why victimization exists as a head of claim. It's to protect people who are in employment, who bring a discrimination claim within the course of their employment. What you can't do is sit as an employee, witness some discriminatory conduct and complain about it 10 years later because you're still in employment. That sort of submission would run completely roughshod over not only the existence of victimization as an independent head of claim, but also the very clear and precise time limits that are set up in Part 9 of the employment law. What we say is that my learned friend's submissions about the time limits are unsustainable. What Your Honour needs to look at is whether any of the claims brought in this instance have been brought within 6 months of the relevant act that has been complained of and that has been pleaded. So that's the general observation on the legal provisions. Breaking down the reasons we say the claims are bound to fail, I'll deal with victimization first. This doesn't actually have anything to do with time limits, Your Honour will note. Really, what our application says here is that the defendant has entirely failed to apprehend, first of all, what victimization actually entails, and second of all, has failed to plead any facts that are capable of supporting a claim for victimization. And as I say, as a reminder, a victimization claim is subjecting an employee to a detriment because they have done a protected act. And that protected act means bringing discrimination proceedings, giving evidence, and so on. And it is, we say, impossible to see what that could have been in this case. The only act that the defendant identifies as being potential acts of victimization in his pleadings are his dismissal and the 14th of September 2022 email, which is sent by the claimant to his partners. So that's on the date of dismissal. But that case is fundamentally undercut by what the claimant himself actually says. So if I can ask you to look at page 143. This is the claimant's first witness statement, and I'm looking at paragraph 34. Yeah. And what he says is the claimant's conduct, which amounted to discrimination and victimization, was a continuing event which did not end at the point of my unlawful termination and continued until the claimant introduced my good name in the financial services community in the DIFC, UAE and beyond. I faced discrimination in the form of racism, Islamophobia, toxic workplace culture, etc., loss of income and job prospects. Then the final sentence there says, hence, the claimant's conduct amounting to discrimination and victimization extending over the period of my employment, and so far as I know, continued until the email dated 14th of September 2022 to asset management companies and financial institutions, including insurers and bank, the email was the last event in a chain of continuing events over 4 years in which they traduced and trashed my good name in the insurance industry globally and ended my career and rendered me unemployable. So that's the allegation. That's what's said to form the basis of this particular claim. And he repeats, for the record, exactly the same assertion at paragraph 22 of his second witness statement. But that allegation can't make sense. First of all, at the time of his dismissal, the defendant hadn't brought any proceedings under Part 9 or done anything in connection with Part 9. All of those allegations were only raised after the event and in the context of these proceedings. So logically, the defendant can't have been victimised in the course of his employment in the way he says, because the Part 9 complaints that he says he relies on were only ever raised after the event. So the first time we get to a Part 9 complaint or anything approaching a Part 9 complaint postdates the 14th of September 2022, by which time the last of the alleged act of victimisation has already taken place. The second point is that the defendant hasn't pleaded or identified any other protected act in his witness evidence or in his pleadings. And there are a number of Justice Giles authorities on this, but the point we rely on from those authorities are that you can't simply plead a conclusion of law, i.e. I was victimised, without pleading the facts on which that conclusion is based. So he can't come to the court today and say, well, I'll come up with another allegation in due course, and that will be my victimisation claim. And the third point, and I think probably the most critical point, is that the defendant's own case is that he wasn't dismissed because of any protected act. So if we look at what's in the pleadings, page 46 of the bundle, does Your Honour have that?
Yes.
So first of all, paragraph C. The defendant was terminated in bad faith by the claimant. Defendant had openly declared his interest in joining one of the top-tier rival firms of the claimant, and this was known to the senior management of the claimant. On 7th of September, the defendant received a written offer from Charles Monat Associates Limited, and the defendant was considering this offer. This was well known within the claimant and in the wider market in Dubai. On 7th of September, the defendant discussed this offer with Mr. Ashgar Abid, who's the head of wealth planning at Bank of Singapore, TIFC branch, and there's an extract from that. And the defendant continues at subparagraph D. At this point, the claimant would have known that the defendant would be resigning and either joining Charles Monat Associates or IPG Hayden, the claimant's bigger rivals. Losing the defendant as a broker would mean substantial loss of revenue and profit for the claimant. Accordingly, without any justification and in bad faith, on the 14th of September 2022, the claimant instead terminated the employment agreement with the defendant and also launched an active smear campaign within the UAE, which would ensure that the defendant would be unemployable within the insurance industry and that Charles Monat Associates would withdraw their offer. Giving that the classic summary disposal treatment, i.e. the court assumes that the facts pleaded by the defendant are made out, the question is, does he have a claim? And the answer must be no, because based on his own pleaded facts, he was terminated because it was known that he would be resigning and joining a rival firm. And precisely the same rationale is given behind the smear campaign launched against him, by which he means the email sent on the 14th of September. And this isn't a slip because he makes precisely the same point in his witness evidence. So if we turn up page 209, so this is his third witness statement. which Your Honour will note is a statement that was drafted when he already knew that the claimant was applying to strike out his victimisation claim. And what he says at paragraph 33 is, I was employed with the claimant until 14th of September 2022. So I'll wait until Your Honour has that page.
Yeah.
On my last day of employment with the claimant after terminating me on the same day, the claimant, without justification, sent an email to asset management companies, insurers and financial institutions, including banks, and reduced my good name by informing them as follows. And then it's subparagraph A. The claimant had no justification to send this email. It was a pure act of victimisation. I was terminated because I was going to work for the claimant's competitor, who are more successful, have better work culture, and have a better client coverage than the claimant. And really that tells one all that one needs to know, because what's apparent is that the claimant, or the defendant rather, just hasn't understood what victimisation actually is. He says in his witness evidence and in his pleaded case, I was terminated because I was going to join a rival. Well, I'm afraid that going to join a rival is not a protected act, nor does it relate to a protected characteristic. So assuming for today's purposes, as you must, that the facts asserted by the defendant are correct, the question is, does he have a viable claim under Article 60 of the Employment Law? And the answer to that question must be no, because he doesn't assert that he carried out a protected act. In fact, he says that the reason he was dismissed, the reason he was subjected to a detriment, was because he was joining a rival firm. And so we say that's fatal to the claim.
Yeah.
Moving to the discrimination claim, that essentially falls on two fronts. So dealing briefly with the first point, because it's what I've just articulated. The defendant's pleaded case, which he supports with the witness evidence we've looked at, is that the 14th of September 2022 dismissal and the email sent on the same date were actually sent, and the acts were actually taken because he was going to join a rival firm. So once again, even assuming that the defendant's case on the facts is made out, those aren't actionable instances of discrimination, because there's no causal link between, on the one hand, the less favourable treatment, i.e. the act of dismissal, and any protected characteristic. So his dismissal and the letter has nothing to do with his race or religion or any other protected characteristic. On his own case, he's dismissed because he's going to join a rival firm. And having another job offer isn't a protected characteristic. So if one assumes that that is the case, one then needs to look at whether there is any other potentially discriminatory conduct alleged to work out whether or not there is a viable claim. And in the pleadings, what we have are only 3 pleaded instances which are capable of engaging Article 59, which are alleged acts of Islamophobia or racism. But the salient point is that the first of those events took place on the 4th of April 2019, and the last took place in April 2022.
Yes.
So if one removes the act of dismissal from the panoply of potentially discriminatory conduct, the last in the series of continuous acts, which if one accepts that is true, that took place and that has been pleaded is April 2022. But even giving the defendant the benefit of the doubt, so not looking just at the pleading, but looking in the round at what else he says in his evidence, there are other allegations made in his witness statements, but all of those predate April 2022. And I've referred to them all in my skeleton argument. But one of the examples, I think, predates the defendant's employment by about 4 years. So it follows, based on that evidence, based on the pleadings, even if we assume, as I say, there were continuous acts of discrimination, the last of those, which has been asserted in any way, took place in April 2022. But the defendant's claim, counterclaim, wasn't presented until the 13th of February 2023. So that's after the expiration of the 6-month time limit. So what that means is that the defendant's pleaded claim and his evidence claim can't bring him within the time limit provisions set out in Article 61(2) of the employment law. And just before finishing off that point, I want to address, Your Honour, on this point about what is the last in a series of discriminatory acts and at what point should time start to count or start to run. You'll have seen in my skeleton that I'm not aware of any authority for this in the DIFC, but what we do have is authority on a comparable point before the Employment Appeal Tribunal. It's at page 1462. And obviously we would accept that this isn't directly binding precedent. This is the UK employment regime, not the DIFC regime and so on. But the point I'm referring to in paragraph 33, I think ought to make the point of principle clear. So paragraph 33, in order to give rise to liability, the act complained of must be an act of discrimination. Where the complaint is about a conduct extending over a period, the claimant will usually rely on a series of acts over time, and that's usually to bring someone within the time limits. He says each of which is connected with the other, either because they are instances of the application of a discriminatory policy, rule, or practice, or they are evidence of a continuing discriminatory state of affairs. However, if any of those constituent acts is found not to be an act of discrimination, then it cannot be part of the continuing act. If a tribunal considers several constituent acts taking place over the space of a year and finds only the first to be discriminatory, it would not be open to it to conclude that there was nevertheless conduct extending over the year. To hold otherwise would be to render the time limit provisions meaningless. So in this case, if we adopt the assumption that there are continuing acts of discrimination extending over any period of time, the last specific act that is relied upon anywhere takes place in April 2022. But given that the defendant's claim is presented in the 13th of February 2023, in order for him to have any in time acts of discrimination, those would have had to have taken place after the 13th of August 2022. So one can clearly see that it's out of time. There isn't really any answer for that. Certainly not one that's before the court. So putting those two things together, i.e. the act of dismissal and the sending of the letter on the defendant's own pleaded cases were not discriminatory acts because they were carried out because he had taken up a job offer elsewhere. The only other acts of discrimination he complains of are out of time and therefore liable to be struck out. So that's the submission on victimisation and discrimination. Your Honour, there's also the, if I can put it this way, the abuse application, which I can deal with, I think, relatively briefly as well.
Yes.
And the reason I can deal with it briefly is because a lot of it ties in with much of what I said at the outset on privacy and the defendant's conduct of these proceedings, which we say.
Well, I don't need any persuading that the private acts, personal acts outside the scope of business of any of the directors or other people involved in the claimants are irrelevant. The only relevance of anything personal is the allegation that there is hostility between the owner of, I'm sorry, it's not the owner, is it? It's the two Mr. Cho's, the brother-in-law, isn't he, of the other firm of Monat. And the only relevance, it seems to me, goes to animosity between the two, and therefore said to be the motivation for the sacking of the defendant is the fact that he was going to join a rival company which is headed up by someone with whom there is a relationship of hostility. Otherwise, I don't think there's any relevance to any of it.
Yes. And what we say arises from that is, stepping back, what is the purpose for which these matters have been pleaded and referred to in the pleadings? And you'll have seen from my skeleton, we referred to an extract from the White Book. There's no firm point of principle. Essentially, the court won't allow its process to be abused. And it has an objective, in line with the overriding objective, to counteract deliberate or encourageable behaviour which would cause injustice, or to protect litigants. And really, it's an exercise of a broad discretion on the part of the court. The White Book itself says that the exercise is pretty fact sensitive. You've got a two-stage test. Is the claimant's conduct an abusive process? And if it is, the court has discretion whether or not to strike out the claim. And we say that that application, in respect of all of this irrelevant stuff, is made out in this case. And you'll see that we're referring to paragraphs. It's effectively two categories of assertion made in the pleading. So it's the documents and pleadings referred to in paragraph 49B and 60G. So those are the allegations that say that the claimant, together with its business partners in the UAE, and that names Bank of Singapore, Mashreq, and NBD, are all operating without requisite licenses. And there's the second category, which is the personal allegations category. So those are the points of the statement of defence and counterclaim which refer to and exhibit the letter sent by the claimant's legal advisors, which contains all of that information. And so in very short summary, the reasons we say the allegation should be struck out are they're irrelevant, they're baseless, they're unsubstantiated. There's no conceivable basis on the regulatory law as to why those are issues for the claimant rather than issues for the DFSA. And so the conclusion that one would draw is that they have been included for an improper and collateral purpose, that is, to harm the reputation of the claimant and its clients in a public forum. But there's also a practical side of this too, because it's apparent, or it's at least been actively threatened on a number of occasions in the letters, that one of the things that the defendant is purporting to do is to join the US Department of Justice and 14 other parties to these proceedings in relation to those allegations. So this isn't purely a hypothetical point. What we say is that the application to strike out for abuse serves a legitimate purpose, because, as I say, the defendant is actively threatened to join 15 other parties as a consequence of irrelevant allegations. If those allegations aren't struck out, in order to preserve its own reputation, the claimant is, of course, going to have to provide what could well be a voluminous amount of documentation and evidence detailing why it disputes those allegations concerning its regulatory status and its adherence to DFSA rules. Where, by contrast, taking action now and striking out those parts as an abusive process is likely to prevent the defendant from making a hopeless joinder application, and also will save an inordinate amount of time and cost, dealing with irrelevant, complex factual issues. And to get an idea of how much cost can be generated by producing irrelevant material, one only needs to look at the defendant's schedule of costs for this hearing, which incur hundreds of thousands of dollars in the preparation of documents, hardly any of which have been relevant to the issues. And as I say, the other paragraph 60A and 60B, those are in relation to the personal allegations and the legal letters that I've already taken your honour to in part as part of the privacy application. But as we say, it's irrelevant because it's about the private life of Mr. Lowe and his family. It's immaterial. It contains irrelevant proprietary information, the names of the claimant's business partners who have nothing to do with this dispute, details of turnover, and the personal data of end clients. It contains private communications, salacious allegations about employees who, again, have nothing to do with this dispute, and repeats the baseless allegations about the claimant's partners and their compliance with GFSA administered rules. So we say that this is very much a case of the defendant trying to apply pressure in a way that is completely collateral to the proper use of the courts and proper purpose. The actual purpose here is to cause embarrassment, not to win a claim. And that is an abusive process. And we say those are the grounds in which the court should, in this case, exercise its discretion to strike out.
Two questions. First, in relation to what's alleged about the Bank of Singapore and the DFSA decision relating to the Bank of Singapore, what is said is that this impacts on the loss of business because the Bank of Singapore is no longer able to make referrals, or at least that's the implication, of and obtain commission, and therefore the loss of business that the claimant suffers from the Bank of Singapore is not due to anything that the defendant did, but due to its own problems in relation to regulatory requirements. So I'd like you to deal with that. And the second point is quite how one deals with the issue that I've already mentioned in relation to Mr. Simon Lowe, the CEO of Charles Monat. It's that there are a whole series of allegations about Mr. Calvin Lowe's behaviour, which has led to animosity and a bad relationship between him and Mr. Simon Lowe, who is his, or at least was his brother-in-law until his wife died.
Yes, Your Honour. Well, dealing with...
Yeah.
Sorry.
That's it. Yeah, those 2 points, please.
Well, on the first point, it's not simply the case that the defendant has turned up and said, here is the decision notice issued by the Financial Markets Tribunal about the Bank of Singapore. And if he did do that, one, it's a public document, so one can hardly see there being any particular issue with that. But for other reasons and in other cases, I've had calls to look at that decision notice. But what it's about is the Bank of Singapore's compliance with enhanced due diligence and its due diligence procedures and the way that it kept its books and its records. The allegations that are being made not only about the Bank of Singapore, but the claimant and other banks, is at the heart of why we say it's an abusive process. And those allegations are, here are a series of established international businesses and businesses which have been conducting business as banks and financial institutions in the UAE for a long period of time, who are carrying out that function without being regulated at all or regulated properly at all. And those are very, very serious and unfounded allegations. So if the defendant wanted to go plead reliance on a public decision notice of the FMT, as being relevant to Bank of Singapore's withdrawal of its business, he can do so. But the abusive element here, and the reason for seeking those provisions of the particular claim was struck out, are because they are alleging much more than that. So if one find the reference.
Well, 49B relates to Mashreq and Emirates, and I mean the plea is inadequate on its face, because what the defendant's understanding is neither here nor there. You know, he has either to plead a breach which is somehow positive of the loss which the claims alleges, or not, so that on its face of it, that plea is unsustainable. But in relation to the Bank of Singapore, it's paragraph 47, is it?
We have said 60G. So I think there are a number of the paragraphs which appear in the application notice to strike out, but those relate to victimization and discrimination elements. But the points that relate to this abuse application are 60G.
Yes, no, I understand that. That's nothing to do with Bank of Singapore as such, is it?
Apologies.
Yeah, okay. No, I'm with you.
Apologies, I'm waiting for my copy of the defence to load, but I've got it now.
(47) and 48 are the paragraphs that are pleaded in relation to the loss that's claimed.
Yes.
But you're not asking for those to be struck out as such?
No.
No. All right. Okay, anything else?
Bear with me, I'm just checking one thing.
Yes, sure.
And yes, really just for completion. So the other parts we're seeking struck out are effectively the references to it's references to the letters being exhibited. But I think you have that point. But I don't think I've got anything more substantive. Let me just check mine's now. I don't think I've got anything from my instructing solicitors. Before I finish, a point has just been flagged for me to stress, coming back to the point about commissions, simply to highlight that part of the claimant's case, the commissions have always been paid at the end of the financial year. And so if you leave prior to the end of the financial year, you don't get commissions, but that's really comes back to some of the arguments for trial and so on. But aside from that, I've got nothing to add.
It's the calendar year, not the financial year, but it may be the same in this case.
Yes.
Yeah. All right. No, understood. All right. Thank you very much, Mr. Doherty. Mr. Patrick Joyce.
Your Honour, thank you. And I think it falls to me to respond compendiously, both in relation to. I haven't got my camera on. Thank you. I'm obliged. My apologies for not having my camera on. I now have both camera and sound. Your Honour, it falls to me to respond compendiously to matters raised by my learned friend both before the short break and after the short break, and I shall do so as expeditiously and quickly as I can, but there is quite a lot to respond to, and I will take it in the sequence of submissions, even if there is on occasion undue repetition. I will try to avoid repetition, but on occasion some points were raised at one point, then come back, then my learned friend reverted to those points, and because of the sequence of my notes, I may need to pick up points on that basis. Your Honour, by way of general introduction, when my learned friend was resisting the application to strike out, he went through the pleaded particulars of claim in some detail, and I accept that A, he needed to do that, and B, he was in a sense invited to do that. So I temper the point I now make with those provisos, but in my submission, my learned friend was conflating two matters and in danger of making or turning the question into a mini trial, which obviously is expressly not the purpose for a strikeout application or an application for immediate judgment. And I say the conflation is as follows. It is clear that there are factual matters in dispute, but that is accepted by the defendant, and the defendant puts its application to strike out on a different basis. It is a question of looking at the claim form and then looking at the particulars of claim and asking essentially one question: do they set out a fit case? And in our submission, for reasons which have already been anticipated in relation to earlier submissions, they simply do not. My learned friend sought to characterize the way in which we put our argument as being a straw man argument. It is not a straw man argument. One looks back at the claim form, and the claim form clearly says and puts the case on the basis of the defendant causing the claimant to enter into the referral agreement with KBC. The learned friend then goes on to say that the straw man argument has nothing to do with the core allegations of this dispute. In that regard, my learned friend, in my submission, eloquently makes the case for strikeout, because the straw man argument is derived from the very wording of the learned friend's claim form, and yet he now says, well, his claim form in essence has nothing to do with the core allegations of the dispute. Because it's on the same page as my notes, it's slightly out of sequence. Your Honour did raise clearly the question as to whether some commission being prima facie due, then there should be an inquiry now, a taking of account, because of the clear admission by Mr. Chin. It's paragraph 42.5 of his first witness statement, that even on his calculations, $685,000 worth of commission is due and owing to my client. We don't accept that that's the right figure. We say it's far too low. But
At
on
most.
any,
He doesn't admit it. He says at most.
well, he says it. Yes, he says it. Well, again, it rather makes the point that Your Honour was making. Shouldn't we have a quantification now? Because it's a matter which will have to be resolved in due course. He has done a calculation, doubtless on the basis most favourable to the claimant, but accepting entitlement on behalf of the defendant. And he himself comes out with $685,000. In my submission, it's a clear example of exactly what is being proposed, namely that there should be sooner rather than later quantification of that which needs to be resolved. I've taken that point rather out of sequence because it was on a page of my notebook, but I can now turn the page and revert in sequence to my learned friend's submissions. My learned friend accepted that there was a need for amendment. He accepted that he could look at some points and other points would need to be looked at. But in our submission, it goes much further than that, because it really does go back to the fundamentals, and it's the fit case point. Pleadings are supposed to set the agenda for trial, and before that, tell the defendant the case that the defendant has to meet. And in our submission, one just needs to look at the claim form, just needs to look at the particulars of claim to see that those fundamental elements are not respected. Learned Friend then, before he was, I think, encouraged to look at other points, did start explaining the basis on which the business arrangements worked. And he said that the claimant generated referral fees. Well, that's not strictly true. It was Cayman who generated the fees, and that was an arrangement between Cayman as broker and the party, either the referring party or the insured. And what the claimant was doing was providing services under a brokerage service agreement. It is not an agreement whereby the claimant provided brokerage services. It is an agreement whereby the claimant provided services to the broker.
Yes, and indeed anything else would have run foul of the regulatory law.
That's why they had to be quite careful about doing it in that way. And that then sets up the fundamental issue, as my learned friend I think now accepts, that the business was undertaken by the related entity.
Yes.
But he then reverted to say that the Bank of Singapore had long-standing professional relationship or relationship which was held by the claimant. The claimant was simply providing ancillary services. The relationship was, as we understand it, and now seems to be clear, if with anyone, it was with Cayman.
No. That's unreal, Mr. Passion Choice.
Well, is it?
Yes, the services are provided by the Middle Eastern branch to Cayman, but of course it's the branch that has the relationship with people in the IFC. That's how it works.
Well, they are the immediate point of contact.
Yes,
but
that's what Mr. Khan was doing.
Well, yeah, of course.
Otherwise, there'd be no work for them to do at all.
But the professional relationship, my lord, the relationship which the doing of the business in relation to the insurance was a relationship which, as we've just identified, was by Cayman, because that was licensed to undertake that business, not by Middle East because it wasn't licensed to undertake that business. The conflict of interest seemed to be a matter which I think possibly has now been largely resolved on the basis that, if there are any points that my little friend wishes me to make, I'll make them at the end in the course of just as a sweep up point. Moving on to the conflict of interest. The point was the court asked my learned friend to examine the position, namely that if the position of a senior employee chooses to seek, or a senior employee of a bank chooses to seek insurance through any agent, whether related to him or not, is there any reason why that senior employee should not do that? And that, in our submission, is the nub question. And it was a question that my learned friend strove to answer by talking about risk and by talking about other jurisdictions and raising unparticularized prospects of bribery, kickbacks, etc. But when one stands back, what is the conflict of interest in what takes place? There seems to be a unity of interest rather than a conflict of interest. The court then continued by asking if any individual seeks insurance, they can go to anyone who can refer insurance, and the example of solicitors and the like was given. The question then was explored further, and the court said we can't see the problem of the managing director using KBC in itself. And the court asked, indeed, whether the court was missing anything. In our submission, no, it was not. And that is precisely the point that we were raising at the outset of the skeleton argument. And I take your honour to paragraphs 5 and 7 of our skeleton argument, where in paragraph 5 we said the claimant has never explained what the conflict of interest was. We've then cited the response by KBC. My learned friend says that's self-serving, but he still hasn't explained what the conflict of interest really was. And in our submission, it comes down to what we say in paragraph 7 of the skeleton argument, namely that the conflict of interest was perceived but never explained, and indeed never was. And that, in our submission, is the length and breadth of the conflict of interest. There isn't one. And of course, going back to the claim form is premised on a conflict of interest, indeed, between husband and wife. My learned friend then moved on, again, still before the adjournment, to look at sections I and following of the particulars of claim, in an attempt to make good his argument that the particulars of claim in their present form set out causes of action. But each and every element, we can look at them if need be, but we've already done so, Your Honour. Each and every element of sections I, J, K, L, M is premised expressly on the referral agreement. And in our submission, the learned friend has not begun to grapple with the fact that the referral agreement was with Cayman, not with the claimant. The question about, no, I dealt with that. Just moving on from section I to section J, my learned friend, as I understood it, and my note, is that with regard to paragraphs 52 little 3, 53C and 53E little 3, that my learned friend was constrained to accept that there was an error and that those paragraphs would need to be amended. And after discussion with the court, my note of what he said is that the factual pleading there can be, in other words, accepting the need for, can be changed. And this comes back to the main point. We cannot be expected in my submission to respond to a case which has not been properly pleaded. I think I can now move to the question of commissions, which was addressed after the break. My learned friend said, well, first of all, the defendant's application for immediate judgment is set out in paragraphs 55 to 97 of my skeleton. Your Honour, I know from previous interchanges or Your Honour's had an opportunity to read what's set out there, so I won't take the court through that. But so far as commissions are concerned, the basis of the commission arises from the contract of employment, which we have already seen. It is in clear and categoric terms. In terms of entitlement, i.e. in terms of liability, the position is clear. My learned friend seemed to be addressing not liability but quantum, in that he said it's not entirely clear well what the commissions are, and he talked about net and gross, and he took the court through the particular provision at the end of the contract of employment, which I won't take the court to. It's already been investigated, but that in our submission is the very point. That is why we say we need to make an inquiry, we need to take an account. The claimant has this data, and we need that data in order to quantify the liability. My learned friend then went on to raise a number of issues which in our submission is simply designed to obscure and obfuscate. The reason why it's designed to obscure and obfuscate is because the parties have been in a relationship since 2018. So the entitlement to commission has been calculated in previous years. It is therefore something with which the claimant is fully familiar. It should not be so difficult. It should not be difficult at all for the proper computation to be agreed. And it is going to be a substantial sum of money owing to the defendant. My learned friend then turned from commission to review the position as regards libel, breaches of regulatory law, expenses, victimisation, and unnecessary pleas. I accept that the focus of his further submissions was on victimisation and discrimination, and the striking out of what he says are unnecessary pleas. As far as libel is concerned, I fully accept that there is not a law of defamation in the DIFC, and the closest that one can get is to, and in my submission it does cover the point, just as there is a tortious obligation in the provision of references, so if you are an immediate erstwhile employer, you have just terminated the employment of your employee, and you take it upon yourself to write a letter which is clearly defamatory and publish that letter to business partners, then that, in my submission, does fall within a breach of the law of obligations. It is a particularly egregious act which the claimant took, and there must be recompense, there must be a cause of action, and in our submission it lies in the general wording of Article 18 of the DIFC Law of Obligations. But let me focus now on victimisation and discrimination. And for these purposes, I need to take the court to the wording of the statute. And I think it's at page 1414. I have it in hard copy, but I'll just pause while the court brings it up.
Page again?
1414 for victimisation.
Thank you.
I think my learned friend probably indicated by way of direction that discrimination is at 1411, victimisation is at 1414, and lest it be lost sight of when we come back to discrimination, I think he referred to race and religion as being the points. We also add nationality because Your Honour will have seen rather derogatory references to my client as a Paki, and we think that it's untrue, it's inaccurate.
He's a Scot.
He's a Scot, exactly. So it is untrue, but plainly there was a national slur, as well as racial and religion. So
it doesn't really add much whether it's race or nationality, does it? But anyway, same
probably
point,
not. But I'll come back to that when
Yeah.
I deal with discrimination. But let's look at victimization and see what the law says. Subsection 1 could not be in more categoric and general terms. An employer must not victimize an employee. For the purpose of this part 9, an employer victimizes an employee if it subjects the employee to a detriment. And just pausing there, that is entirely consistent, that breadth is entirely consistent with the breadth of subsection 1. There is then an or, which is disjunctive, or dismisses him because the employee does a protected act. So it is the dismissal because of doing a protected act, which also falls within the definition. But that definition, or that part of the definition, after the disjunctive or, does not cut down the general scope and breadth of the earlier part of the definition, which is of an absolute piece with the unqualified statement at section 60, subsection 1. And then, of course, there is elaboration, explanation of a protected act. And therefore, if the employee brings proceedings or gives evidence or does anything in connection with that, or makes an allegation of a contravention, then that is a protected act, and dismissal falls foul. But those are particular species, maybe not exclusive, of how an employer can victimize an employee. But one is really driven back to the general statement at the outset. And that, in my submission, was overlooked by my learned friend because he sought to make everything subject to the doing of a protected act. When one stands back, the scope of a victimization provision must be general, and rightly so. The learned friend then took the court to to Article 61.2, and as far as my recollection and note is concerned, did not take the court to Article 61.2b, because it is right that Article 61.2a introduces a time limit. But that time limit is qualified by B, which opens up the time limit extensively, because the alternative to the time limit set out in A is where a complainant satisfies the court that there are circumstances which justify disapplying Article 61.2a, such other period as the court considers reasonable. And a learned friend sought to argue that we were relying on Article 10. We are not relying on Article 10. We are relying on section 61.2 and 3, read as a whole, as they must be, because the Article 61 is expressly referred to in Article 10, and Article 10 establishes the usual limitation period of 6 months. We have the alternative in Article 61.2b, which we've just looked at, and then one goes on to 61.3, where for the purposes of Article 61(2)(a), conduct extending over a period is to be treated as done at the end of the period, and failure to do something is to be treated as occurring when the person in question decided on it. There's the problem here with victimisation and with discrimination is essentially, Your Honour, that a leopard doesn't change its spots. And what we have done is we have identified clear examples of whether it's victimisation or discrimination throughout the course of Mr. Khan's employment. The rather derogatory references to the mosque as a cottage, the plainly discriminatory reference to him as a paki, the allocation of all the Urdu clients to Mr. Khan, the matters which are set out in paragraphs 25 to 20, sorry, pages 25 and 26 of the statement of defence and counterclaim, which is in paragraphs 60F. And I can do no better than invite the court to look at what 60F says. The claimant has actively engaged in racism and Islamophobia. By way of summary, being a person of colour and a British Asian, witnessed racism in throughout his life. He's sensitive about racism and abhors and rejects it in all manifestations. Sustained racial abuse in the office from the claimant's senior management. One such instance, senior management referred to him saying, "Hopefully you realise that comment this morning about the dishwasher guys was a joke. We would certainly not make racial comments in the office if there was anyone there that we didn't see as family." It doesn't, with respect, matter that there was some sort of perception of family. And why should family be an excuse for racist comments? Then goes on, again, it's highlighted, "I'm sorry, but I've taken it personal. We need to talk about it tomorrow. I think it would be best to involve Eric." It was plain that Mr. Khan took exception to the problem. Again, I simply invite the court to look through what is said at subparagraph F, little Roman 1, little Roman 2, little Roman 3. And some of the points I've made already, other points arise from that in relation to, again, derogatory references to the Almighty Allah and the Prophet Muhammad, peace be upon him. That is confirmed in the witness evidence at C2, which is Mr. Khan's first witness statement. And forgive me, it's in a different. Yes, C2, one sees at the foot of page, well, it begins at page 7 of C2, paragraph 15, which refers to the toxic work culture, and the details of racism and Islamophobia are then turned to at the foot of page 8 of that witness statement, paragraph 19 and following, suggestions that the mosque might make a beautiful cottage and matters like that. And then going on to the general office culture, going through to paragraph 22, which takes matters through to the 7th of September 2022. So a mere week before the termination of my client's employment. Now, what one has here is a picture of examples of a clear course of conduct. It comes back to the fact that leopards don't change their spots. And in the context of victimization and discrimination, it is a very emotive issue, and employees are in a significantly worse position in terms of bargaining position compared with employers. They want to remain in employment. It does not mean that they should accept discriminatory behavior and victimization and generally objectionable behavior. And on that basis, we say that the time limit in Article 61(2) cannot be read as only 6 months from the date of any particular incident. We also rely, my learned friend says this is after the event, it was after the termination. We also rely on the fact that within hours of the termination, the defamatory letter was given wide publication. That if the court wishes to find a touchstone for the continued behavior transgressing the line of victimization, transgressing the line of discrimination, because the claimant was vindictive given the alternative employment to which Mr. Khan was moving, the Simon Lowe animosity between Mr. Simon Lowe and Mr. Calvin Lowe. What one has here is something which is, in our submission, clearly established through until the termination. The termination was on the earliest date. The learned friend said, well, it might be a later date because of the 30 days, etc. The earliest date of termination was obviously the 14th of September 2022. The defence and counterclaim was served on the 13th of March 2023. It is within time applying the Article 10 limitation period, and that goes back to the submission that it cannot have been the court's intention, there cannot have been the legislature's intention to shorten and abbreviate the period of limitation for something as grave as discriminatory conduct and victimization. My learned friend said, well, of course, you can't complain 10 years later. That, with respect, is not what we are doing. We are complaining promptly, and in this regard, Your Honour, I would ask the court also to bear in mind that there was no grievance procedure. It's a point made in our skeleton argument, but you will recall, Your Honour, that the contract of employment says the grievance procedure and the disciplinary procedure will be as per the DIFC employment law. When one looks for grievance procedure in the DIFC employment law, one finds reference to it, but one finds reference to it in Article 14, which relates to the what must be provided in the context of a written contract of employment, and at 14(2)(k), that says an employment contract shall include a reference to any applicable disciplinary rules or grievance procedure. So we know from the signpost in the contract of employment to the DIFC employment law and the reference back from the DIFC employment law to the contract of employment that the arrangement put in place by the claimant was entirely circular, and there was therefore no grievance procedure, let alone no proper grievance procedure for him to raise these matters. That again is a highly material fact which we urge the court to bear in mind. My learned friend goes on to say that we failed to apprehend what victim. And my learned friend, yes, my learned friend points out that during the course of his employment, Mr. Khan escalated the matter from Mr. Parker to Mr. Chin because of the passage that I've already read out when he said, well, we've got to talk about this tomorrow, and he took it further. So it wasn't as if he was sitting on his hands even as an employee. But my learned friend says we failed to apprehend what victimization is. In our submission, we have not at all failed to apprehend what victimization is. Victimization is quite clearly being picked on. Victimization and discrimination can overlap, being picked on for reasons of race, nationality, religion, but also the victimization inherent in being dismissed as soon as it was known that Mr. Khan was leaving the claimant's employ and moving to Charles Monat, which was headed up by Mr. Simon Lowe. In terms of further matters, just making sure that I've covered all of the points. Yes, in terms of discrimination, there I do need to take the court back to page 1411, which is the Article 59 of the employment law, which contains the provisions in relation to discrimination. Does the court wish me to pause or continue?
Carry on.
Thank you. We've already covered the grounds of discrimination, race, nationality and religion, which apply in present circumstances. 2A, an employee is treated less favourably than another is or would be treated in the same circumstances, or put at a disadvantage not faced by others because of a prohibited ground, i.e. race, nationality or religion, that a provision, criterion or practice is applied to an employee which is discriminatory in relation to one of those grounds. And we go back to the points which we've already covered as part of victimisation, that he was referred to as a Paki, that he was given Urdu-speaking clients, that there was clear Islamophobia, and the racism which we've already covered. 2C, one of the elements of discrimination is the violation of an employee's dignity. Again, we say it is quite clear that Mr. Khan's dignity was violated in all of the instances that we have given. Then going through Article 59, an employer's actions in dismissing an employee or subjecting them to a detriment are discriminatory under Article 59(1) if they contravene Article 59(2). And we can see that the reason for dismissal, which is set out in the pleaded case, was that Mr. Khan was going to work for someone who the claimants did not like. I think, you see, do I need to refer to Article 59(4)? Well, I think I can deal with that compendiously in that it really supports the analysis that I've set out in Articles 59, 1, 2 and 3. The remainder of Article 59 relates to disability, and I don't need to trouble the court with that. So we say that contrary to my learned friend's submissions, the claim in discrimination is actionable because it is dismissal, which relates to protected characteristics when one reads Article 59.2, but in any event, we rely on the continuous process, and my learned friend seeks to make my apologies, seeks to make a point based on the Southwestern Ambulance case in the UK, in the England Wales jurisdiction, the Employment Appeal Tribunal, on the basis that the act of dismissal, the sending of the letter, was not discriminatory, and all other matters were out of time. We respectfully disagree for the reasons that have been set out. The abuse of process gave rise to further discussion of the animosity between the claimant and Mr. Simon Lowe, and again we rely on that. I should deal with almost two final points. My learned friend makes much, or in relation to the letters, my learned friend makes much of a list of potential parties who might be joined to the action. That was written in the context of the letter on the 19th of January. That was the first opportunity that Mr. Khan had to substantively respond, because there was no grievance procedure. It will not have escaped the court's attention that there has been no joinder application, and I'm instructed that no joinder application will be made. So that becomes, in our submission, a non-point. In relation to the Bank of Scotland, the Bank of Singapore DFSA decision, my learned friend concedes and acknowledges that that is a public document and therefore is a matter on which we can and do rely as an explanation for the loss of Bank of Singapore's business. It was because it could no longer make referrals and therefore be part of the commission arrangement post-October 2022, when that decision was published. So far as the second point that the court raised, the 2 points at the end of my learned friend submissions, one on the DFSA decision, which I've dealt with, the other was the issue with Mr. Simon Lowe. And again, we say that that is relevant to the way in which our client was treated. Your Honour, I have tried as best I can to respond on the hoof to the points which have been raised by my learned friend in the course of his oral submissions. Of course, in relation to our application for immediate judgment, we have set out our case extensively in the skeleton argument beginning at paragraph 55 on page 13. The court will have that in mind. We've also dealt in that context initially, but to be carried over to the response to my learned friend's application in relation to discrimination and victimization. That section begins at the foot of page 17 of our skeleton and goes over the page to page 19. And then in relation to my learned friend's application to strike out parts of the statement of defence and counterclaim, that's dealt with in part 4 of our submissions. They build on the previous parts, as the court is well aware. We have focused on those parts which are now before the court, the 4 paragraphs of the statement of defence and counterclaim and the 3 exhibits. And in relation to those, the case is summarised at paragraphs 108 through to 110, first of all, the claimant has throughout impugned the defendant's business ethics. We seek to respond to that grave imputation so far as Mr. Khan as an individual is concerned and as a practitioner within the insurance industry. We respond by saying, first of all, the allegation levelled against us is not right, but if it is to be alleged at all, then really it should be levelled at the claimant. And in our submission, what is set out in the two paragraphs 49B and 60G reasonably set out our case in that respect. So far as the other two paragraphs are concerned, 60A and 60B, they form part of the case. Sorry, I've put, there's an error. It says in paragraph 109, it should not be C's case, it should be D's case. So it should read, the statement of defence and counterclaim paragraph 60A and 60B form part of the defendant's case on respectively his claim for commission and expenses and his claim for repudiatory breach, and we say they are sound heads of claim and should not be struck out. Exhibits 5, 7 and 8 are inter-solicitor correspondence relevant to those heads, and on that basis we submit that the claimant's application should be dismissed. I wonder if I could just ask the court to give me the indulgence of 1 minute to take instructions from my co-counsel to ensure if there are any other points that I should place before the court.
Yes.
Now, there is one further point which is of particular concern to my instructing solicitor. In a sense, it's ancillary, but it's very important. As Your Honour is aware from the full evidence, the claimants have made complaints to the police in Dubai. Those complaints extend beyond Mr. Khan. And of course, Mr. Khan provided the documents and returned the documents as soon as he was able at the police station, as you've seen back in September last year. The police complaints, I'm afraid to say, extend to those instructing me, and not only to those with carriage and conduct of this litigation, but extend to partners of MB Kemp in Dubai. The result, Your Honour, is that my co-counsel cannot travel to Dubai for professional purposes, and his co-partner, his fellow partner in Dubai, Mr. Imran Shafiq, cannot travel out of the UAE. Now, I say it's ancillary because it doesn't go directly to any point in the litigation, but it demonstrates the extent to which the claimants will go, and it is again a matter of grave concern for obvious reasons to those instructing me that they should have their professional ability to carry out their professional job and represent clients in Dubai, other clients in Dubai, that these obligations, that their ability should be fettered and restrained. And it is something that those instructing me particularly wish to be raised. I've raised it, I hope, in an appropriate way. I accept it does not go to the issues in the pleaded case, but it is very important in terms of professional propriety. And I would have hoped that certainly there should be no fetter or restraint placed on legal professionals in carrying out their business.
Well, that I understand, Mr. Patrick Joyce, but I don't think there's anything I can do about it.
Well, Your Honour, the DIFC does have a code of conduct. It has a code of conduct which is mandatory for those legal professionals who appear before it. And if one, whether on I assume on instructions, so I assume that this is what the claimant has instructed his legal representatives to pursue. As I understand it, legal representatives for the claimant have made criminal complaints against legal representatives from MB Kemp and Company for the defendant. And if there is not a means of policing that within the code of conduct, I would be very surprised. It may be that we have to take it up outside the four corners of these applications and my submissions today, but it is raised fairly and squarely as a matter of grave concern.
Well, I understand that, but as I say, I don't think there's anything I can do about it. I think it probably does have to be taken up with Professional Conduct Committee if that's what's thought is appropriate. I mean, I say at once, I think this is a case where neither party has shown the restraint that should have been shown, and I would hope that lawyers on both sides would bring to bear the elements of reasonableness and sensible advice that one would expect of professionals in the business of the law. I regard that as highly important, but beyond that, I don't think I can go.
Well, Your Honour, even those words are considerable solace and comfort to those instructing me. Your Honour, unless there are points that Your Honour has, those are my submissions in response to my learned friend submissions.
No, thank you very much. Mr. Doherty, I don't think I need to hear from you unless there's anything particular you want to say.
I have very few points of clarification, if nothing else, which I can probably deal with in a couple of minutes.
On what?
On submissions made on victimisation, on the points actually being relied on by my learned friend on time limits, and the examples of conduct that were given. And really, actually, I could probably do that in about 3 sentences, which is to say that the submissions made that victimisation is a broadly encompassing term, which can include being picked on, or presumably on that analysis, being told off for mistakes in your work, not being involved in a tea round, who knows, fall within the scope of victimisation. That's clearly not the case. Victimisation is pretty clear under Article 60. My learned friend said he didn't rely on Article 10. He does. It's a paragraph 82 of his skeleton argument. The only way that he tries to bring the claim in is to refer to Article 61(3) and continuing conduct. But when he went on to give examples of what actual discriminatory conduct there was, he referred to the out of time conduct in April 2022 and a Facebook post, which I think was from 2014, if my recollection is right. So again, they're out of time. There's nothing under Article 61 2b where the burden is on the defendant to satisfy the court that there's a reason to disapply. That provision generally, for what it's worth, is there to capture scenarios where if someone has been subject to racist bullying in work and they've gone off, for example, on long-term sick leave, the first thing that comes to mind isn't necessarily bringing a claim. And those are the sorts of circumstances where one would find disapplying the normal time limits, but they're there for a reason. And unless the defendant comes to you with a reason to disapply them, which he hasn't, there's no reason to. A final point being made on the fact there wasn't a grievance procedure somewhat underscores the point that there can't have been any protected act prior to January 2023, which we're now told is the first occasion that the defendant saw fit to raise his complaints of discrimination. And then one final point, if I may, just really is a wrap-up point on my learned friend's submissions on his applications about the Cayman entity having had the relationship with the banks and doing the brokering. And really it's to point, Your Honour, to the fact that if one goes to the employment contract at clause one, what we have there is a definition of capital C, the company, as being the Middle Eastern entity. So that's Reli Middle East. That's page 918. And if then one goes to the commission entitlement provisions that my learned friend and the defendant rely upon, that's clause 5.7, which we've already looked at. So those are the provisions saying that, you know, you have to receive payment from the insurer before you become before the right to payment crystallizes. And what that provision says is that the entitlement to payment of commission crystallizes when the company, capital C, receives its commissions from the relevant carrier of the insurance policy. So if my learned friend is right, that because it's Reli Cayman and not Reli Middle East, that's the broker, and it's the one that entered into the referral agreement, and it's the one that deals with the insurers, well, on that interpretation, he isn't entitled to any commission at all, because Reli Middle East will have never received any commission from the insurer. And really, that's just to highlight the fallacy in the way that the defendant's case is put.
Your Honor, I hesitate to interrupt, but my learned friend has just referred the court to the employment letter of the 1st of November 2018, which is at D9, and there is a material difference between that and the actual employment letter and the contract of employment of 2021, which is at page D, which is at tab D15, and makes clear that the submissions I made were accurate.
All right. Anything else?
No, I'm obliged, Your Honour.
Right. Well, I'm going to indicate to you what I'm going to decide, and I'll give you some reasons in writing in greater detail. But the reason I'm doing this is because I want to discuss the further conduct of the case with you. First, I consider that the counterclaims for victimisation and discrimination should be struck out. Secondly, I consider that there should be a strikeout of pleas that are embarrassing and which are likely to obstruct the fair and just disposal of the case. That means essentially deleting the references to the letters which contain a great deal of material and particular parts of the defence and counterclaim, which I shall set out in my reasons, but are broadly speaking 49B and make sure I get this right. Yes, 49B and 60 parts of 660, but particularly 60F and so on goes with the victimisation and discrimination. So far as the application of the claimant of the defendant is concerned for strikeout or summary judgment, the position is, to my mind, this: the essence of the case that is being made by the claimant is clear enough for the defendant to respond and does not depend upon the wrongful reference to the referral agreement being between the claimant and KBC, as opposed to being between the Cayman Island Company and KBC. The essence of the case relates to the deceit by the defendant concerning the position of KBC, the two conflicts of interest which are alleged to arise as between the beneficiary, the wife, and the referral agent, KBC, as per para 21 of the particulars of claim, and that between KBC and the employee of the bank, which in reality seems to me to raise also the question of conflict between the employee and the bank itself in paragraph 49. It's the deceit of the defendant in either specifically misrepresenting, as he is said to have done, the recommendation of KBC, the nature of KBC, and failure to disclose who was involved in KBC, that is the essence of the claim, with consequent diversion of business from the Bank of Singapore as a referral agent. Having said all that, I regard the pleading as being wholly inadequate to express the case that is being put in terms of expressing exactly what the wrongdoing is. Although it is clear from the statement of Mr. Chin what is being said, the pleading needs to set out the matter in express terms. So the question I need to ask is how long is needed for the claim form and particulars of claim to be put into appropriate form, properly expressing the case as to the wrongdoing. And secondly, within that, also expressing in clear terms what the case is as to the commission which is owing and the expenses which are owing. And in the context of setting out the case as to what is owed to the defendant, I am going to order that there be disclosure of the critical documents which support that plea, so that although I'm not ordering that an account be taken, the effect of it will be for the claimant who has the relevant information to set out all the material so that the court can see exactly what is being said and the figures can be quantified. And if there are then arguments which arise on the construction of the commission compensation scheme and the preconditions and so on, they can all be looked at in due course. In essence, the reason why I refuse the applications of the defendant is because at the end of the day, this is a fact-sensitive case, and it all turns on the KBC issue, if I can put it in those terms, and whether or not that justified the termination and gives rise to any claim of any kind on the part of the claimant for supposed loss of business. If there is a valid claim, then there is potentially a set-off against whatever sums are owed by commission. But the focus needs to be on exactly that. And what I hope to achieve by the orders that are going to be made is that the focus becomes very clearly on termination, the reasons for termination, whether or not it was justified, and whether or not any loss occurred to the claimant as a result of what is said to be the actions of the defendant. It's helpful in that sense to not to have to deal with the victimization and discrimination claims, which are, for reasons that I will come to, time barred and unsustainable in relation to absence of protected acts and so on and so forth. What I want to do really is to set a timetable now, which the parties are happy with, to move this matter on. So the first question for you, Mr. Doherty, is by what time can you deal with an amendment? It may very well be that the easiest thing is not to use the existing particulars of claim, but actually to come forward with one which is drafted in a more conventional manner of the kind that English counsel would ordinarily do. which focuses on pleading facts and not argument. And then together with that, as I say, pleading both the case as to wrongdoing and as to the amount of commission which the claimant says would be owing to the defendant but for its claim of set-off with disclosure of documents. Then it would be a question as to how long the defendants need to put in an amended defence. And I actually think, subject to anything the parties say, that the easiest thing will be for effectively a fresh start on both sides. Neither of the forms of pleading that I've seen are likely to assist the court as much as having pleadings which are drafted in a more conventional manner, which don't descend to argument, but set out the facts upon which reliance is placed and the course of action in each direction. And if I can encourage counsel to be involved in that activity, I would be pleased to do so. Then, of course, there'll need to be a reply and provisions for disclosure and what is to follow thereafter. Mr. Doherty, you first.
Yes, I think one of the material questions I have is whether you contemplate that the disclosure of the information will be subsequent to the pleadings or whether those should be appended to the pleadings, because that might make a difference in the timing of when those will be available, because obviously there will be the prior step of needing to actually collate all of the information before
Yes, well,
the case commission is pleaded.
It seems to me if you're going to plead a case as to what you say the appropriate commission is, you're going to have to look at all the documents anyway.
Yes.
So the two things should go together. I don't see much point in asking you to plead something which is only a halfway house.
Yeah, I had understood that, and I thought that might well be the case, but I thought that might be relevant. If I can I ask for a moment just to speak to my instructing solicitor on WhatsApp just to get an idea of what's viable in terms of timing. I do note, Your Honour, I think I'm before you a week Monday, which will occupy a little bit of my time in the period that follows. So when it comes to actually pleading, I might have to factor that in. But if you
no doubt you'll factor in your engagements and anybody else's engagements, but I need a realistic timescale.
Thank you.
But I, as I say, I am keen really to get this case on what I regard as a proper footing. I'm afraid I don't regard 30-page letters as being helpful, and I don't regard a great deal of irrelevant material relating to personal lives as helpful. You know, I understand that the parties feel strongly about this case in both directions, but I expect the lawyers to exercise a restraining influence in focusing on what is required and eliminating that which is no more than vindictive or salacious or scurrilous or embarrassing within the use of that term in the rules of court. Do take some instructions, Mr. Doherty.
Yes, thank you, Your Honour. Your Honour, I think, bearing in mind, sorry, just opening up my diary. Yes, I was going to suggest 28 days, which would, well, if we were to set it to say by the end of the week, it would be the 26th of May, which would enable my instructing solicitor to make sure that all of the information is ready, and then once it is, after I've finished before you on a trial starting the week of the 8th, I'll then be able to turn over to this alongside a couple of other commitments.
It's a 2-day trial, is it?
It's either 2 or 3. I did check. 2 days, I think.
Right. Okay. I'm not. I don't think I have any knowledge of its content at all. So, on the face of it, Mr. Patrick Joyce, as long as you get enough time to respond, 26th of May sounds to me reasonable enough.
Yes, my learned friend has told the court about his position. I'm not. I'm sympathetic, so I don't want to put him under undue constraints. And indeed, we. What sauce for the goose is sauce for the gander, Your Honour.
Yeah, yes.
I was thinking we would want 28 days after that.
Very good. What date does that give rise to?
If he's the 26th of
I
May,
think that becomes the 23rd of June.
Does.
All right. And then a reply, amended reply.
I mean, I would expect 2 or 3 weeks to be fine for that. I'm just checking.
I wouldn't wish to put my learned friend under undue constraint, but 2 weeks does sound appropriate, and I'm
2 weeks is 2 weeks is normal, but I might allow another week if there was good reason.
Well, 2 weeks will be the 7th of July.
I'm happy to commit to 2 weeks. If it turns out that for some reason there's a huge amount of material unexpectedly, then it may well be that the two sides need to engage.
Yes, well, all right. Well,
there's an agreement extension, but
7th of July, is that?
Mm-hmm. Yes.
Very good. Now, do we need to make specific provisions for what happens thereafter in terms of disclosure and so on, or do I just leave that for the moment and we see where we get to?
I think probably the next step after that would be arranging a CMC and the parties filling in its management information sheets and so on.
Yeah, well, let's do that in a normal way, and then we can review the position. I say my encouragement would be to you, and maybe you want to comment on this now, that actually it would be best to have entirely fresh documents on all sides. I think it would make life so much simpler. Do you have any view about that, Mr. Doherty? I think Mr. Patrick Joyce is in agreement.
Yeah.
Yes, I think that's
yeah.
not a particular issue. It's very much likely to be cleaner.
It'll be much cleaner than trying to fiddle around with what's there and trying to stretch things that are there into things that aren't there.
Yes.
Yes, Your Honour. I think it's very sensible.
All right. Well, let's do that then, and a CMC and so on to be fixed at some time after July.
Yeah, you're the only concern I have about. I see why you say it, CMC to be fixed sometime after July, is the lapse of time, and my client is very concerned about his position for obvious reasons.
Yes.
It's in part matches what I've already submitted in relation to wider concerns, but with the way in which the seasons work in Dubai, if we are looking at close of pleadings on the 7th of July, then there is a real risk that we won't be able to foregather for a case management conference until the other side of the summer, and that would be really wholly inappropriate.
Well, do you want to suggest a date for that, Mr. Patrick Joyce? Is that what you have in mind?
Yes, Your Honour. I'll just have a quick word with my co-counsel, if I may, see if we can find a date. Could we perhaps have the CMC the week after, 14th of July? Now, that's a Friday.
No is the answer, because I can't do the 14th.
Right.
But let me tell you what I can do and see if that's any good to you. It may not be quite what you have in mind, but I think the best I can do is actually the 31st of July, which gets you just this side of the vacation from an English point of view. How does that work for any of you?
I'm happy to make myself available on the 31st of July. And the court is well versed to deeming itself sitting in all sorts of parts of the world. So
Yes.
wherever I am, I hope I can be deemed to be in the court in the DIFC.
Yes.
Thank you.
Does the work for you, Mr. Doherty?
I have one of those clerking blocks in my diary for the week commencing the 31st of July saying 5-day case, refer to clerks. I don't know if that's a firm commitment or a not firm commitment. So I can't guarantee that I'm not otherwise instructed on the 31st. Well, I can say that there's a chance that I will be available, but the only date that I can see that I will certainly be available is either the Friday before or the Monday after, but around there otherwise is clear. It's just that particular week. Apologies to be the source of difficulty, but I suspect I'm going to need to call to my clerk to try and resolve whatever that is.
Well, my only other possibility is in the weeks of the, I can't do anything in the week of the 24th. In theory, I could do something early in the morning in the weeks of the 10th or the 17th. I've got a 2-week arbitration. And I assume, I think sitting hours will probably be 10 o'clock in the morning, London time. But if you wanted to have a CMC at 8 o'clock in the morning, virtually, sometime during those 2 weeks, that being 11 o'clock in the morning Dubai time, that would be workable from my point of view.
Yes, this is the weeks of the 10th and the weeks of 17th in July, yes?
It is the weeks of the 10th and the 17th, and I would suggest the week of the 17th was probably better, simply because it gives you a bit of time after the replies come in on the 7th.
Yes, that's fine from my perspective, and it may well be that I can resolve this 31st issue, as I say, with a call to my clerks. But if we were to pencil in a day on the week of the 17th,
Well, why don't we say, where are we today? It's Thursday today, isn't it? Why don't we say that by close of business Monday, a date will be fixed, either for 8 a.m. in the mornings of something in the week of the 17th of July, or for the 31st of July.
Yes.
All right. And if you would liaise with one another first, and then with the court to make sure the court's happy with that. I can't see the court having a difficulty if it's going to be a Zoom hearing, or Teams hearing, whatever it is we're on. Then we can get stuff moving at that point. All right. Is that all relatively clear?
Yes, Your Honour. I don't know if you're proposing to move on. It seems to me there are two outstanding issues. One is privacy, which may be part of your reserved decision. The other is costs. And
yes,
I don't need to say much about that, but the claimant succeeded in its applications, the defendant hasn't, and we seek our costs.
Well, I'm rather inclined to simply reserve costs, simply on the basis that there's been a, I mean, as I say, I think this case needs putting into proper order, and I'd like to look at it all in the round at a later stage, so it'll be cost reserved. So far as, sorry, what was the other matter you just raised?
Privacy.
Oh, privacy, yes, yes.
Just to check, we're obviously scheduling in a CMC. If costs are reserved, obviously we'll be coming to the CMC with the parties' pleaded positions. It seems that if we're going to deal with questions of costs, that might be a suitable juncture to do it. Yeah, I stress that the reason I press on the issue of
on the basis that the regulatory stuff is going to go, save insofar as it refers to the Bank of Singapore DFSA decision and how that might impact upon any loss of business. it seems to me the privacy points really don't have any great force. And the fact that, you know, you have referral agents who are in the banks that operate in the Middle East, you know, that's blindingly obvious to anybody who's in the industry anyway. I can't myself see that there's any real issues that arise in that context that require particular protection or confidentiality. So privacy refused, I say, on the basis that all the regulatory stuff or complaints about regulatory stuff are going to go, except for the published decision. And so
yes, I understand that that point was to some extent potentially going to be more or less important depending on what the outcome of this strikeout point was. And then am I just to understand in the last point that at the CMC the parties can come prepared, well, can the claimant come prepared to make an argument about its entitlement to costs of these applications at the CMC?
The argument will be mutual at whatever juncture it's had.
Well, I don't accept that, because there has been an inordinate amount of witness evidence generated. I mean, you can see, I don't know if you've seen the defendant's statements of costs.
I have,
but it was claiming two partners, one of whom spent over $120,000 and another who spent $50,000 on work done on documents, most of which were completely irrelevant to the matters before you, Your Honour. By contrast, the applications made by the claimant were properly made. They were on points of law. They didn't involve much evidence. They involved some legal argument, and they were done at considerably less expense than the defendants. That evidence needed to be replied to, and so we will be seeking our costs of these applications. I think it's just a question of when we have those arguments.
But what I'm going to do is indicate what my thinking is in relation to the matters that have been raised. And I don't know how the breakdown of costs would occur, would work out. But I was pretty horrified, I'm bound to say, by the size of the cost figure incurred by the defendants. It seems to me self-evident that at the end of the day, the costs of the application to dismiss the victimization and discrimination cases must go with the event. And that would carry with it, of course, all the work done in relation to victimization and discrimination. And therefore, I suspect a great deal of the costs that were incurred by the defendant in putting together a whole wodge of material that was repeated in the second witness statement from the first witness statement, and in the first witness statement from the letter of the 19th of January. Huge amount of duplication. So that seems to me to be the position so far as those elements are concerned. And likewise in relation to the pleas of breach of regulatory law. So far as the application for summary judgment and strikeout of the claim is concerned, it seems to me that that absolutely is a matter for cost reserve, but where my own view would almost certainly be in the end costs in the case. None of those are views which I'm putting forward as being to be embodied in an order now, but it's an indication of where I'd be likely to go if anybody wants to argue the point in the future, whether that be at the CMC or come the day of judgment following any trial that might take place. But that's the way I see it at present. I'm not inviting you to comment, because that's yes. You can reserve your position as to what you want to argue. I'm not very keen on deciding that at a CMC, which I'm trying to do at 8 o'clock in the morning when I've got another hearing beginning at 10 o'clock, because cost issues almost invariably take more time than one hopes or expects.
Yes, Your Honour. I take your point. I think probably the best course is there's a section in the CMIS which indicates whether there are any applications need to be dealt with. So if we're proposing to deal with costs, then I'll obviously have to take instructions, but there is an issue of my client not wanting to be kept out of costs that it's incurred, that it's entitled to for longer than is necessary. So I'll take instructions on that. But if that is going to be an issue, it'll be indicated in the case management sheet.
Yes, well, as I say, I'm reserving costs, and I'm merely giving an indication as to my current thinking on the subject, which is recorded on the transcript. Should anybody want to refer to it in due course, when costs come to be decided, if they ever do.
Yes, thank you.
And, you know, I'm not unmindful of the fact that the claimants are in a stronger position, I suspect, liquidity-wise, than the defendant is. Right, that's as far as we need to take it for today, I think. Thank you very much, and apologies to the court staff for keeping them late, but thank you for that. I will draft some reasons which will be relatively brief in relation to the defendant's applications, for the obvious reason that where cases are fact sensitive, it is best to say as little as possible, really, at an early stage, because the facts yet remain to be determined at trial, should we get that far. All right, do you think you could sign out, and I'll just have a quick word with the associate, unless anybody wants to add anything at this point?
Thank you very much, Your Honour.
I'm prepared to follow that, and thank you very much, Your Honour.